All right, good morning, everybody. Today's date is October 12th, 2022. This is a regular meeting of the members of the State Liquor Authority being conducted in our New York City office with video conferencing to our Albany and Buffalo offices. This meeting is also being live streamed on the State Liquor Authority's YouTube channel. Present today are Chairman Bradley, Commissioner Fan, and Commissioner Ford. Staff in attendance, Acting Counsel Alvarado, Deputy Commissioner of Licensing Donahue, and myself, Secretary Roper. The next meeting dates are October 26th and November 9th. While in the meeting rooms, please silence your mobile phones and take phone calls or conversations outside. No food or drinks. For those in New York City, the public restrooms are located on the second floor. And please do not touch the microphone when you approach the podium. Items will be called in the order they are signed in, first in Buffalo, then Albany, and then New York City. When your item is called, please approach the podium and identify yourself. Representatives, please identify your clients who are with you. I do have one announcement. So for those that have been using the State Liquor Authority's FOIL email address, that's no longer active. For FOIL request, they have to be made via the state's open FOIL New York platform. The link is on the SLA website. If you do send an email to the SLA FOIL email address, you'll get an automatic reply with the link to the new platform, but no one's monitoring that email address anymore for the State Liquor Authority. Chairman, do you have any announcements?
That's announced conspicuously on our website as well, correct?
I believe so.
Yeah. Okay, no, I don't have anything else.
All right, first in Buffalo, the first item is 1525, ABES Waterfront Bar and Grill, LLC.
Good morning, I'm Tracy Jong. I'm here with James Abel, principal of ABES Waterfront Bar and Grill, LLC. So I believe this has been referred to the full board because there were two prior disapprovals on this. So one disapproval was a prior tenant. We have no connection with that business. My understanding from a FOIL request is that she was declined because she had violations at Empire Grill, another business that she owned. And again, we have no relationship whatsoever to that other business operating at all. So the second matter was a disapproval of the instant application the first time it was put through. Mr. Abel can speak on it, but on his personal questionnaire, there was a question that he answered that had an incorrect answer. He has owned this property for a number of years, and so when it asked, have you owned the business or whatever, he answered yes, because he's owned it for a long time, when in fact he owned the property of the same name, but it had been rented to different operators over the years who had run the businesses there. So technically it was an incorrect answer because he owned the property of the same name. So he corrected that, but you certainly can ask him. It was no attempt to misrepresent. It was the way he answered the question. So we put in a corrected answer, and the disapproval, it was put back into licensing, and so we're here today.
Is that your take on this, Tom?
Sure, what's that?
Is that your take on this? That's not the way I read this.
I have a slightly different take on what information we were given and why it was disapproved. But it was disapproved because of either incorrect or misleading information in the original personal questionnaire, which suggested he was availing the license of the other people who were there.
So you're telling us he was not availing the license. He's never made any money off of this other than rent.
He operated it. He corrected the personal questionnaire. He did operate it for a couple years between 2006, but the other years it was operated by other businesses that were tenants. So when he answered the question, I'd owned the property since 2006. he had owned it, but he was not the operator. So when it
Well,
came back,
that's not what he answered.
That's not the way I read it. That's why I'm asking.
No,
Let me finish. In his employment history, he listed himself as the owner of this establishment. Now, that's not what he may have meant as the landlord, but that's not how it was represented in the personal questionnaire.
But, well, it says here,
No, you have the current one.
right, but it didn't say that before. I mean,
No, the
it
other-
shows waterfront docks, he was there for 5 months.
Right, the questionnaire originally suggested he owned.
Another application.
No, the original personal
Oh,
questionnaire
before he amended it, okay.
suggested he was the owner of the business, this Abe's Waterfront Bar and Grill, at this location for the last 20 years. And that's why it was disapproved.
I see. But, I mean, either way, he has experience and the place wasn't a bad place, right? We're not talking about really bad
Correct.
history or
Right.
anything
Correct.
regardless.
Yep.
So it's just a representation issue. Okay. What are your hours?
You know,
What are your hours?
I usually at noon till 10 or 11 o'clock at night, unless it's Friday, Saturday, then it's open till 1 o'clock. I'm closed
All
now
right.
for the season, but
All right, so I'm going
seasonal
to,
business.
okay. Are you gonna hire a manager or are you gonna do this yourself entirely?
Next year, when I open up, it'll probably just be me.
But I'm gonna just tell you, I'm just gonna give you a manager as needed. Is that okay? And then if
Yeah.
you decide to hire a manager, things,
Yeah,
business grow,
that's
et
fine.
cetera, you need someone. Okay. Are you okay with that? All right, so I'm going to vote to approve with the following conditions. Security guard as needed, manager as needed, recorded live DJ karaoke, music allowed, patron dancing is allowed. There will be no private events, there will be no use of third-party promoters. 2 a.m. across the board.
Commissioner Ford?
Your capacity is 350 people, but you're only asking for one security guard. So I'm going to go with everything that Commissioner Fan just said, but I'm also going to change it to security as needed.
That's what I said.
So you can have more than just one if you need it. Is that all right?
Yeah.
Doesn't matter, it's all right. All right, I'll vote to approve with the same conditions as, I'm assuming Commissioner Fan did say the same thing.
Yeah,
right?
I did.
Okay. You've been approved.
Thank you.
thank you.
Next in Buffalo is 1522. That's Tipsy Liquor and Wine, Inc.
Good morning. My name is Tonya. I'm the principal for Tipsy Liquor and Wine Inc. I'm not sure why I'm here today. I know it's a full board meeting, but I wasn't given a specific reason. So I'm
You,
just here.
you applied for a liquor store, right?
Yes.
That's why you're here.
Well, I didn't get any reason of,
They all,
The last-
every liquor store has to go to the full board.
Oh, okay. Understood.
No protest, huh?
Why do you want a liquor store?
I mean, I've been an accountant for so long, and it's just a way for me to make more money, I guess.
How long have you been an accountant?
For 12 years.
Does anyone in your family own liquor stores?
No, sir.
How far do you live from this location?
About 12 minutes.
All right.
Ready to vote?
Yes.
Yeah.
Commissioner Fan?
I'm gonna vote to approve.
Commissioner Ford?
Pretty small store, and I say, based on your location, it meets public convenience and advantage, not to mention the robust sales of nearby stores, and no objections, so I'll approve as well.
And Chairman Bradley?
I'll approve.
All right, you've been approved.
Thank you so much, guys.
You're
Have a
welcome.
good day.
Welcome.
And Nicole, there's nothing else in Buffalo?
Excuse Excuse me, that's correct. There's no one else here.
Okay, you can go ahead and sign off.
All right, thank you.
There's only one item in Albany. That's 1501 Mahavira Inc. Mahavira Inc.
Hello, my name is Hardik Patel. I'm owner of the Mahavira Inc. Corporation.
So we got some letters protesting this move. Are any of the protesters there?
We do not have opposition.
We have
we
one
do here.
We have some here.
Come on up.
Hi.
Hi.
You want to introduce yourself?
Oh, sure. My name is Beth Lieberman. I'm the property owner of the current premises.
And what's your objection?
My objection is just that I have found that the operator is not a worthy operator. The village needs a different kind of liquor store, and I tried to engage in negotiations with the current owner when we bought the property, and I just found out that he was engaged in various different things that I feel like violates his good faith as an operator, as well as somebody who I was not willing to engage in business with, such as the fact that I know he has an undisclosed financial partner. He has undisclosed sales of higher-end bottles of liquor. He gives shots of liquor to the public, and
Who's the partner?
I don't know
Well, how do you know he's
because
has one?
because he told me.
And what you say he's selling high-end liquor? He's licensed to sell liquor.
Yes, but sort of under the table sales, I should say,
And how do you know that?
because he told me.
So
Okay.
we
so-
have any, did you file a complaint or anything with us other than this?
The letter, no.
And I read your letter. Are you from Ellenville?
I have a house in Wardsboro, yes.
For how long?
For 2.5 years.
And how long have you owned the building?
I bought it 6 months ago from the longtime owner.
How long, sir, how long have you owned that liquor store?
5 years, sir. About
Where do you live?
Allenville.
And you don't think that liquor store is appropriate for Ellenville?
No, I think a liquor store is
No,
appropriate for
his
Eleanor.
liquor store
Yes,
is not appropriate.
Exactly.
I'm not
And the
sure what-
inventory is
but
identical.
he's trying to terminate the relationship with you. He's trying to move from your location.
That's right.
That's actually
So-
not the way I see it, though. It's from my information, she evicted him.
I did evict him. Yes, I
Did
evicted
you
him.
try to buy his store before that?
I tried to engage in it. Yes, I was under the impression, I was told that he was interested in selling the license.
And he told you what?
He at first tried to negotiate with me, and then he didn't, and I found out all this stuff about him as well in the process, such as the sales and the partner, and
So he told you no?
yes, he
And
told
then
me
you
no.
ev- And then you
After
evicted
a
him.
while,
Then
yes.
you evicted him.
No, we terminated the license way before he told me no. The first thing that I did, he had a holdover lease. So he was on month to month since 2020. And so the first thing that I did when I bought the building was I terminated his agreement. I have copies of all this if you're interested. And so I
But
gave him
I'm not
notice.
sure why you're here, because he's trying to move
I
away
guess.
from.
I do too. It's not a guess.
Yeah. I mean, I tried, I'm
No,
fully
you wanna
transparent.
You want to put a liquor store in this spot.
So there has been a liquor store in this spot for many decades.
You want to put another liquor store in
A
this
different kind
spot.
of liquor store, yes.
So I'm from this area,
Uh-huh.
very familiar with Ellenville.
Yes.
And given that you're there 2.5 years, you clearly aren't. This is not how people treat people in Ellenville. So you might not like the way he runs his business. That may be the case. If he's breaking the law, then file complaints and we'll certainly investigate it. But in my experience in Ellenville, this is not how neighbors treat neighbors. So you might want to think about that going forward. But I'm going to vote to approve the removal. He's moving 27 feet. He was evicted because the new landlord doesn't like his business.
He obviously has a right to do business, so I'm going to vote to approve the removal.
Commissioner Fan
I'm gonna vote to approve.
and Commissioner Ford.
I vote to approve as well.
All right. You've been approved, sir.
Thank you.
Yep. And Paula, there's no one else in Albany, correct?
That's correct, sir.
All right, you can go ahead and sign off. Thank you.
Thank you.
Moving to New York City, first item is 1523, Pure Wine NYC LLC.
Good morning, members. Max Bookman
Hold on a
possess.
second, hold on.
Oh. Sorry. That's all right. Good morning, members. Max Bookman, Pizetsky and Bookman PC for the applicant, opening a new liquor store, replacing one that has gone out of business. I see there's opposition here.
Can
Happy
we
to.
have, yeah, there is opposition. Can we have 5 minutes with council?
We're going to go on a brief recess to conference with council. We'll be back on the record shortly. All right, we're back on the record after a brief conference with council.
All right, who's in opposition? You too, Mr. Miller?
Yes, co-counsel. So Charles Lynn, representing the opposition. I represent 3 stores, 33 Union Square West at 140 4th Avenue, MRN Liquor Inc. And today with me is Mark Nanny, who's the principal of that store, as well as Taste Wine LLC, with co-counsel Martin Mailer. Do you need Marty to put his name on the record, or is this sufficient? No. Okay.
Sorry, tell me again the three stores.
33 Union Square West on 4th Avenue. MRN Liquor on St. Mark's Plaza.
Okay,
And Taste Wine at 53rd Avenue.
got it, thank you.
Okay. Public convenience and advantage will not be served by licensing this applicant. Proximity is a saturation of liquor stores. The public is already being well serviced by the current stores in the neighborhood. There are 14 stores within 0.4 miles of applicant. I've attached a survey and list of stores annexed, which I marked as Exhibit A. There are so many stores that the authority, when obtaining its gross sales figures, expanded from 4 stores to 7 stores in order to get the gross sales in this neighborhood. Even then, Warehouse Liquors, this is a liquor store at 735 Broadway. The third closest store to applicant is not stated on the SLA proximity report. This store is but 900 feet from applicant. It's approximately a 7,000 square foot store, which has about 13 million in gross sales per annum. It's not on the SLA proximity because 735 Broadway Liquors INC sold its store in February of 2022, and GB License LLC under serial number 1342380 is operating on a temporary permit. So they've been operating on a temporary permit since March, and it appears hopefully that they will get their full license approval in November, just 2 months from now.
You have that on our list? The store he's talking about, Tom?
No, I don't.
No,
And that store, the size again?
7,000 square feet,
And you said they're
doing about 13 million. The reason I know is that I represented 735 Broadway in the sale, so I knew what the other store was doing. Needless to say, I don't know exactly what they're doing on the
But
temporary.
that being said, that's not a new store, it's a transfer, correct?
Yes, that was a transfer. But again, it adds, as far as proximity, to 14 stores within the area.
Did the DBA change?
No, it did not. It's Warehouse Liquors.
You're representing Taste Wine too, or is that yours, Mr. Miller?
Well, he's representing Taste Wine for the purpose.
So your, obviously your argument is that store still exists?
Yes.
Yes, well, and also Mr. Miller will be explains a different area which I will not be touching upon.
Go ahead.
This Warehouse Liquors is a well-known landmark store.
I mean, this is gonna hinge on what we think of that store, because otherwise, if we think that store doesn't exist, it's gonna replace, their application's gonna replace that store. If we do think it exists, then I'll call you back up and you can do your saturation argument. So I do want to hear from Mr. Mailer first.
All right, just based upon that one topic, and I won't go into my other shtick with regards to my application.
Just remember,
but,
you said that, not me.
I just want to point out that this is very similar to the application that we had for Cinderella Liquors in Hudson Yards, where I had represented a store coming in as a replacement store. We were going to be on the first floor. Cinderella was on the second floor. Cinderella, because of COVID, shut down completely. They put their license into safekeeping. And when I approached with regards to the new application, the board said, well, the license is in safekeeping. We're concerned about having 2 stores there. Is this store going to be in this neighborhood, or are they going to be moving to some other neighborhood? And I had to get a letter from Cinderella.
There's a big difference here.
I don't see.
Cinderella kept their license in safekeeping appropriately, meaning that they notified us, they asked for extensions, they weren't closed for 2.5 years. This licensee here did not ask for an extension and then let that safekeeping basically lapse for over a year.
All right, I will have then Mr. Mailer address
They
that.
just went to hearing last week, and that hearing has not been decided yet, but they went to hearing for being non-bona fide. which I'm sure Mr. Bookman is going to tell me.
Right, and I will have Mr. Mailer address that, but I just would like to point out that there's an advisory 105-5 that specifically says exactly what the chairman said, that licenses can remain in safekeeping for 6 months. If they go beyond that, they either have to surrender the license, begin operation, or approach the licensing commissioner requesting an extension.
None of that was done.
But so that comes up the question as to whether there's extenuating circumstances, and that's why I have Mr. Mailer here to explain to the authority.
Is there anything in the advisory about extenuating circumstances?
What it's,
Let him explain.
Okay.
Tom is being Tom.
That's okay.
Someone has to be.
Thank you, Martin Mailer of Mail and Buscemi. Mr. Landsman would have been here today, except that the ongoing problem that he has with his children, he had to do something today with them. Look, this is an extremely unique set of circumstances. This man had a liquor store. It was his means of supporting his children, or actually of supporting his family, which when it started had no children. He then has the privilege of having a son and a second son. And the tragedy that befell this gentleman after the birth of his children is well documented in many articles. He's appeared in many news shows with respect to what happened to him, and he's not asking for pity. What he did over a period of years was attempt, and was very successful at raising funds and awareness of this disease that wasn't very well known when it afflicted his sons. They're still alive today. He's very grateful for that. He was going to attempt to get the store back together, but what happened in a year ago, was that the landlord refused to renew the lease. He began looking around, did find a new spot. The application has been filed, albeit recently.
Where's the new spot?
It's roughly well, the actual address is 113 3rd Avenue. It's about roughly 1,000 feet, maybe less, from the spot he's at right now. I'm asking the board to consider what is a very unusual set of circumstances. Yes, I know what the bulletin says back in 2015. Yes, he should have addressed the situation with the deputy commissioner in charge of licensing. He did not. But he had SIRS, he had problems, he had other things to consider. And I'd like to also point out that when he first put the license into safekeeping, it was February of 2020. Very interesting time. COVID hit the following month. I'm not using that as the reason why he kept it in all that time, but this board during the COVID period indicated that the formality of putting things into safekeeping had been suspended because everybody realized the unique set of circumstances. His problem, he did not follow up properly. That's the long and the short of it, but he didn't follow up properly because he really did have other things on his mind. He has 2 children. They are getting treatment. Things have happened because of his efforts and his wife's efforts. He's raised more than $6 million towards this terrible affliction. And he's asking that this board understand his plight and allow him to have his store back. I mean, obviously, I'm not here to argue whether the removal should be decided today, but I am asking that this license be considered as a viable license and that it be considered as one of the 4 stores so that this board can make a proper determination. He didn't have any sales for the past 2 years. Before that, I think I gave Mr. Lynn the figures that he had. He needs a second chance in life, and he's asking that this tribunal recognize the uniqueness of the situation and allow. I mean, I don't want to elaborate on his children's problems. It's well documented, but it's for real. He's for real, and we apologize for not following up on the formality of what should have been done. he was basically on his own for most of that time in terms of getting legal advice. He has it now. He's followed up, and I'm asking that this board understand that this is one of the 4 stores.
All right, thanks.
Tell me again where you're planning to move your store to?
113 Third Avenue.
Sorry?
113 Third Avenue. It's roughly 1,000 feet, maybe a little less from where he is now, or was now.
Okay.
And how many square feet is that going to be?
Roughly 3,000, which is what his other store was.
And you said that he raised $6 million. Is that all just towards the treatment, or is there a nonprofit that they're running to?
No, yeah, and apparently this is a whole, it's beyond his own 2 children. The $6 million is
Right,
for
I
the
know,
development
I
of
know.
this.
I'm just asking, like, are they running other nonprofit to raise awareness and you know, because that's.
I don't know the formality of what he's doing, but yes, it's not just his children. I mean, in the sense of this is, he started a movement, and apparently, I mean, as a side issue, apparently what they're doing may affect and help other diseases such as Lou Gehrig's disease and Alzheimer's. So it's beyond this disease itself, which.
Right, but now his intention is to come back.
In a sense, he has to come back. I mean, you know, he has to try to pick up the pieces and start all over again.
Yeah, no, I mean, I fully understand. I mean, you know, in the beginning of COVID, if you have 6 children at home, you're certainly not trying to run a retail store.
Right, but I mean,
Just for clarification, I think you said 2020 was put in safekeeping?
2021.
2021.
Yeah, I'm sorry.
Fair enough, which is the same.
I'm sorry.
All right, Mr. Bookman.
Thank you, and hello again, members. I was going to make 3 points. I'm going to skip the first 2 and go straight to what was going to be my third one, which is addressing the arguments that you just heard from Mr. Mailer, because I tend to agree with the chairman that this case comes down to whether you determine that Taste is an actual store that is still open and has a chance of reopening or not. I think this whole case hinges on that.
No, it actually doesn't. It's a question of whether it's hinging on whether the license was effectively surrendered or not.
Well,
I mean, if it reopens in a new area, that's neither here nor there. But currently, if it's still in existence, it exists.
That's a more accurate
at its
statement.
address.
Agree. That's what I meant to say, and I'm going to address the removal. Public convenience and advantage. That's what the statute commands you to determine. We have deep sympathy for Mr. Landsman, Mr. Mailer's client. We said that in our complaint to the authority before we knew the charges had been brought. That's Exhibit A to our papers. We said that again in our papers. Our application for a store in no way detracts for our sympathy for him. However, this board is tasked with determining what is in the public convenience and advantage as it exists currently today. And as it exists currently today, there's overwhelming evidence, I don't think anyone is disputing, that Taste is out of business at that location. I mean, we provided photos inside and out. I mean, my client was originally going to take over that store. We included that narrative in our submission, and when the landlord ultimately decided he didn't want another liquor store tenant, and so we had to, so we went as far as submitting an application for that store to replace. And when in the course of doing that, that was back when there was attorney certification, we did a walkthrough of the premises. It was empty, and we have photos to that effect. Their website is defunct. There's no gross sales figures. The license was was put in safekeeping in 21, not 20. Counsel's office, your own counsel's office brought charges, so they agree that the license is non-bona fide. And Exhibit B to Mr. Lynn's papers, which I only had an opportunity to see after submitting my own papers, so I didn't have a chance to address this in my papers. But Exhibit B to Mr. Lynn's papers is Mr. Mailer's removal application, which was, an 11th hour application filed, only a few weeks ago before the full board meeting. In that application, it says that they lost their lease. That meaning Taste is acknowledging that they lost their lease. There's no proceedings to have them come back. There's no court cases where they're alleging that they need to be brought back into the space. So everyone is in agreement. There is no argument before you here today that Taste is returning to this location. So if you accept the fact that Taste is not returning to this location, which I think you must, then the only other question is, and this was raised by Mr. Lynn just now and in his papers as well, is whether your typical public convenience and advantage analysis is somehow modified by the fact that this store, which has been closed for almost 2 years, recently filed a removal application that you're going to hear 7 to 9 months from now, if it even gets to you. I mean, you know, that location that he's allegedly removing to, we went and visited that location. It's still on the market for rent. The real estate brokers are still selling it for rent. So I don't know if there's a lease. You haven't even given it a serial number yet. So that landlord could change their mind. There's no guarantee that application is even going to come before you. And when it does, there's of course no guarantee that you're necessarily going to approve it. So at its core, what this comes down to is a topic that is frequently referenced in these liquor store cases is, do we as a full board determine applications based on speculation? And what Mr. Lynn is asking you to do is speculate. He's asking you to speculate that this removal application is going to come to you, and then you're going to approve it, and then because you're approving it, that's going to lead to a net increase in liquor stores. But that's exactly backwards.
Speculate. I mean, I think that the point is that technically, depending on how this, I mean, technically, there's a license in this location right now.
I think
whether it's, you know, non-bona fide or whatnot, you know, they didn't extend properly or whatever, like technically there is a license here. So this is not ripe enough for decision. That's what I think.
I mean, consistently, as Mr. Lynn pointed out, in the Citarella case, that licensee was no longer in that space. That space was gone.
I'd like to address both of those points. First of all, and if I can do Commissioner Fan's point first and then come back to Chairman Bradley's. Commissioner Fan, I think only in the most technical, bureaucratic sense, there is still a license here. No, I don't think so. No, I disagree, Chairman, because the legal standard here is public convenience and advantage.
No, it's not on the other store. You're trying to tell us that you're trying to get us to make a determination that the other store is already canceled, because otherwise your client can't get a license.
No, Commissioner Fan, I disagree. We have no. First of all, we have no position on their removal application. You know, my client, if you approve his license, he has no intention of opposing that removal application. I don't know if Mr. Lynn's going to be back here in 9 months to oppose that removal.
Did you try to buy this store?
The store is out of business. There's nothing to buy. My client did speak, and he puts this in this affidavit. He did speak with Mr. Landsman, and Mr. Landsman said cryptically that he's keeping the license active by design. But I really want to get to this point. I'm not asking you to prejudge the proceeding that your counsel's office. No, look, I can please explain.
I wouldn't be able to issue a license here.
I disagree, Commissioner Fan, and here's why. Public convenience and advantage does not prohibit you from issuing this license. We're not applying for a license at this location. We're applying for a nearby location. You're not prohibited from issuing a license at a nearby location. So there's nothing that prohibits you.
Now you're arguing that we should assume that license, even if it's still at that address, that adding your client's stores in the public convenience and advantage. I would say, looking at the facts, if that's the way I'm supposed to rule, it's not.
That's not what I'm arguing, Mr. Chairman. What I'm saying in response...
Our practice and the law indicates if the license is in safekeeping, it remains at the address it's at.
What I'm saying in response to Commissioner Fan is that Commissioner Fan said that she is prohibited from issuing a license if that license is still active. All I'm saying is that's not correct. And what is correct is...
It is correct.
Well, what is correct, if I could please just get this point out. You're required to consider public convenience and advantage, and what's been going on. Hold on, please.
Stores are going down numbers.
That's not correct. There are several stores with up numbers, and I have points on that. But public convenience and advantage, if you look at what's been going on in this neighborhood for the past year and a half, is that this neighborhood is down a liquor store, and it's going to remain down a liquor store for the foreseeable future, if not forever. There's no argument before you that this gentleman is ever returning to this store.
You're asking us to speculate on where he's removing. What if he removes right next door?
That
application is not in front of us right now.
He doesn't get a hold on the neighborhood because one day he may remove his store.
Safekeeping gives him that.
No, Mr. Chairman, when he comes
Do you have law that supports your position? Because I don't think there is any.
When he comes to remove his store, when that application is before you 7 to 9 months from now, he could make his public convenience and advantage arguments then as to why at that point in time the neighborhood is in need of a new store. Public convenience and advantage doesn't say that there's a moratorium on the issuance of new liquor licenses when a store is out of business, and no one is arguing to you that he's coming back here.
You're missing her point. That license is still at that address.
There's no business at that address.
That doesn't matter.
Yes, of course it matters. It is blind. You're being blind to the facts on the ground. Everyone, including your attorneys, agree that store is not coming back.
I think that it's just not ripe enough. I'm not saying your client cannot have a store,
Not
but
right.
not when there's another store still there.
Commissioner Fan, he's been out of business and no one's claiming that he's not out of business for years.
Because I think he's taking himself off.
We're gonna go on a brief conference with council. We'll be back on the record shortly.
No comment?
All right, we're back on the record after a brief conference with council.
May I make one final comment?
Yep.
What the opposition is trying to do is affect a net reduction in stores in this neighborhood by one. There's a store, Taste, that's clearly out of business. Everyone knows it's out of business. They know it's out of business. And they'd like to keep the number of stores in the neighborhood down by one.
But the law allows them to do that.
Well, first of all, the law doesn't.
That's what safekeeping is.
Well, you've already issued them violations for not following
that's
your
not in front of us
procedures.
yet.
But although the law allows them to put licenses.
Here's my problem with your argument, Mr. Bookman. You are asking us to consider things that are not before us. Yes, apparently violations have been committed. Apparently there was a hearing. That's not here.
But
we're not here to do the enforcement of that because the case isn't in front of us yet. You're asking us to consider a removal application.
No.
That's not here. Well, you're asking us to consider the fact that they filed one.
No. They asked you to consider that they filed one. I'm not asking you to
We had
consider
a
that they filed one.
situation, Besides the Citarella case, which you still haven't explained to me why we were wrong, and you represented Citarella.
Oh, I'd like to explain it
The
to you.
second one we had was where a woman in upstate New York passed away that owned a liquor store. By the time that she passed away and the son inherited the liquor store had been closed for months. A new landlord bought the building, applied to have a liquor store there because theirs was closed and the license was in safekeeping. This board unanimously rejected that application because the license was in safekeeping, allowed the individual to remove the store, and then the landlords later opened the store.
Well,
Now, that's what we've done before. So tell me, you're telling me now that everything I've been doing for the last 7 years is wrong, and it may be.
well,
But that's what you're telling us.
there's two examples you've just given, so I'd like to be able to respond to those examples. In the Citarella case, we sidestepped this issue. This issue did not get adjudicated by you in the Citarella case because we were able to get a letter from the licensee saying that they're moving to, I think it was Long Island, but
But you don't have that.
you took evidence, Mr. Chairman, that they were not coming back. You took evidence, Mr. Chairman, in that case, the evidence you took was the letter from Citarella saying they're not coming back. In this case, there's a plethora of evidence before you saying that they're not coming back. Mr. Mailer's not arguing that they're coming back. No.
Even if we accept that, he just told you he's moving 1,000 feet away, makes him one of the closest 4 liquor stores.
Well, and he can come 7 months from now and argue to you why public convenience and advantage would be served by putting a liquor store there. It's going to be a different number of 4 liquor stores. It's not a neighborhood removal. It's coming to you 7 to 9 months. My client's not going to oppose his application then. I don't know if these other stores will.
You're missing the point. He's within the area that we would consider. He's trying to remove, he's in the area already as a licensee. He's removing, arguably, we don't even know because it's not in front of us.
Exactly.
But he's removing within the area that we would consider for public convenience and advantage. He's affecting everything.
And you can adjudicate that application when it comes to you. It's first come, first served. If a new applicant came to you and said,
asking us to put the cart before the horse.
no, they're asking you to put the cart before the horse. They're asking you to assume that you're going to approve a removal application that's not going to be before you for 7 to 9 months. We have no
If we
idea.
don't approve it, it's still at the location it's at.
They're not coming back there. It's empty. They're not coming back. No one is claiming that they are coming back. You're being blind to the facts, Mr. Chairman. Excuse me, my papers are replete with evidence of that, including your own counsel's office evidence. Look at the store. It is empty. Their landlord said they're not coming back. They said they're not coming back. They are not coming back. There's a plethora of evidence.
You still have not explained to me why what we have consistently done in the past should be changed.
What I'm telling you, Mr. Chairman, is that it's different than those cases.
How's it different than the one in upstate New York?
It's different in degree. This store has been closed.
We don't do degrees.
This store has been closed, and your counsel's office has brought charges against them. That's what's different too. Your own agency has determined what they've done is wrong here, and now you're going to let them benefit from their wrong by holding a moratorium on the number of liquor stores issued in this area until 7 months from now, when you may or may not approve their removal application. I mean, that's going to be an opposed application. These other stores.
Do you want us to remove or allow this store to go in because the degree of their safekeeping of the license is greater than the degree of the...
I want you to allow this store to come in because your own agency has determined that store is no longer bona fide, and there's no one arguing here before you today that they're not.
We went to trial and the decision hasn't been...
All right, well, it's going to come back and it's going to be sustained. And what are you going to do? You're going to give a civil penalty and tell them to open back up? They don't have their lease anymore. You're going to cancel their license, and even if you don't, you're going to give them a civil penalty and tell them to open up? They're not opening.
You're telling me you're not putting the cart before the horse, but all they have right now is an allegation against them, has not come before this agency, which really, whatever this agency done is directed by this board. And the board has made no finding, has not seen one fact of the case that you're talking about.
You're being
so you don't even have a horse. Your cart so far away.
You're being blind to the facts that are before you. We have put undisputed facts before you that this store is closed. I'm not asking you to cancel their license today, but in determining public convenience and advantage, you can determine that for years now, this store has been closed and the neighborhood is down a liquor store, and there's no evidence before you that they are ever coming back. In fact, the evidence before you is that they're not coming back because they're removing.
You're repeating
And
yourself.
going
Thank
back to, and you know, the number of stores, going back to your point, the closest stores are all doing down numbers, you know, the third closest store, fourth closest store, 7 million in 18, 5 million in 21. That's a really significant drop.
We put arguments in that in our papers, Commissioner Fan.
It's got nothing.
There's inconsistent numbers. The numbers of the stores that are going up are all either boutique stores or high-end stores serving the increasingly affluent community of this area. We got data from the census, not from some website, from the census showing that the affluence of this neighborhood has skyrocketed in the recent years. And the stores that are doing poorly are the ones that have, and we showed pictures of this, you know, frozen margarita popsicles in their windows and other lower-end products that are appealing to a demographic that is increasingly not present in this neighborhood. My client is not going to compete with the stores whose numbers are going down. The stores whose numbers are going up, the boutique sake store, the store that has Astor Wine and Spirits, which is a high-end store, their numbers are all going up. And the reason they're going up, we submit, is because they are catering to the demographic that remains in this community and that is increasing in this community. So there is public convenience and advantage here, especially given the fact that this...
Are you trying to argue that the East Village is starting to get gentrified?
Well, the Union Square area is. Yes, I am arguing that.
It's been that way for years.
Well, we have census data showing that from 2011 to 2020, which is the decennial census period, the mean area income has almost doubled in that period. And so, and it's only going to get more gentrified. So this neighborhood is down a store. And that's just the fact. The last point I just want to get across, because I think it's just gotten lost in the shuffle here, is that you consider the facts on the ground. One of the indisputable facts on the ground is that for the last year and a half, perhaps as much as 2 years, there has been no liquor store on this block. And this neighborhood is down a liquor store as a result. We're looking to replace that store.
Thank you.
Members ready to vote?
Yep.
Commissioner Fan?
I mean, on both fronts, the fact that technically there's still a license at this address in safekeeping, and we haven't really decided on, and that has not been adjudicated yet. Between that and also the fact that these numbers are just dropping so quickly, I don't see public convenience advantage. I'm going to vote to deny.
Commissioner Ford?
Most of us up here are parents. So, you know, we get it with what these folks have been going through with their kids over the past couple of years, you know. Our heart aches for them. It's not something we would wish upon anyone. But I have to look at this as a commissioner here tasked with a job that's not always pleasant to do. As I see it, the location has been empty now for a while. I've looked at the pictures. It's definitely abandoned. They have, I'm not asking us to wait till a hearing bureau comes back with a decision. At this point, to me, it's almost like irrelevant. But as I see it, they have officially applied to us for a removal to another location. So as I interpret that, that to me means that their intention is not to return to this location. If I'm wrong about that, somebody stop me here. but my interpretation of that is that they are not planning to return to this location. They've applied to take their business elsewhere 4 or 5 blocks away. So to me, that means that this neighborhood that had a store is now down a store. And so for that reason, I would approve this one because in my mind, they are replacing a store that intends to, not just intends to, but has officially applied to go someplace else. So for that reason and that reason alone, and I wish them all the best luck, and who knows what's going to happen when that gets here, but it's a ways away. And to me, 4 or 5 blocks away in Manhattan, that's another county. So I'm going to vote to approve this one.
Chairman Bradley.
So and this is basically on our agency, because it takes so long to do a removal, which probably would be 6 or 7 months. I am going to, I'm going to vote to approve. What I'm going to base that on, though, is if this place does end up there, they're going to be able to go back there, and you're going to have a competitor that's 272 feet away from you. Because there's nothing we can do to stop them from going back there, because they're already there. I will certainly keep this in the back of my mind, giving the mitigation that Mr. Mailer's presented due to the family circumstances, that if they don't go back there and they decide that they're going to move a block away, they're probably going to be able to do that too. So I don't expect to see you here, period, objecting to anything in this neighborhood.
Yes, sir.
Because why Mr. Bookman would like everyone to believe that you've shown compassion, I don't see any. So the only reason I'm doing this is because the alternative was to adjourn this for 6 or 7 months, and I'm not going to do that to you. But I am going to tell Mr. Mailer that more than likely you're going to have an advocate up here when your client comes for a removal. So I'm voting to approve.
Thank you. Thank you, members.
Next is 1526 Chelsea Winery Limited.
Good morning, everyone. Robert Romano. I'm here with Amelia Gankars, who is the principal of Chelsea Winery Limited. This is a removal. The license has been in safekeeping since August. We are moving under 400 feet away to a smaller space. I believe the only reason we're here, or one of the only reasons we're here, is due to the fact that the 4th and 5th closest stores have changed.
You're moving from inside of Chelsea Market?
Correct.
To outside?
Correct.
Okay,
So we have protests here? All right, we did get 2 protests of
Right.
this removal.
But they think
My
it's a new
understanding
store.
is the protest letters were protesting a new store
Correct.
and not a
All right,
removal.
I find public convenience advantage in that. I'm going to vote to approve.
Commissioner Ford.
I'm going to vote to approve as well.
And
It's
Chairman
actually a smaller
Right.
store you're going to, right?
I'll vote to approve.
It's a much smaller store.
I hope anyone going into Chelsea Markets is watching this hearing, because I'm assuming it wasn't as lucrative as you thought it would be.
Definitely not during COVID, no.
Oh, right.
That's why their numbers.
All right.
Thank
Good
you.
luck.
Thank you.
Next is 1512 RL Malone Inc.
Robert Romano again for RL Malone Inc. This is a conditional no contest plea after consulting with the counsel's office and my client of $3,500.
I'll approve.
I'll approve.
Commissioner Ford.
Accept it.
Thank you. Thank you very much.
Next is 1510 5 O'Clock Forever LLC.
No idea.
Good morning.
Yes.
This was put over for us to figure out closest stores.
Yeah, Tom, what did we figure out here?
I don't think it's a question of the examiners missing places. There were so many places. I sent you an email earlier about this. We used the first 5 that came up on our proximity report. There's no question there are other package stores at around the same proximity, the same distance as those 4 or 5.
Right, we just don't go that far, right?
Well, and also is our system isn't as detailed as far as exactly how many feet. So that's those are the 5 that came up. Those are the 5 we used.
It was also a Google
But
Maps
there's no,
glitch.
but there, and I checked on Google Maps, the distances are what's reported in the memo. I'm not disputing that there are probably quite a few places that are around the same distance, which may, if you walked it or did an actual measurement on the ground, number 6 might actually be number 4, that sort of thing.
Right.
But we used what our system came up with.
There was also a Google Maps glitch where if you put the same address in Google Maps and any other mapping program, it actually indicates that it's a couple blocks south from where it actually is.
I noticed that as well. Yeah.
Which is I think what Mr. Springer had done, and when he told me about this, we checked it, and my clients were aware of this because in their searches in the community, they found something similar, that when they looked in Google Maps, it was very different than when they looked in any other mapping program.
What is it then? Bible, that's the case.
This one. This one.
Okay.
So Joseph Levy here on behalf of the applicant, 5 O'Clock Forever LLC. This never really got started last time. I know there's opposition here. If you'd like to
Yeah,
hear
you
from
can
them
let
first.
them go first.
Never mind.
Good morning, John Springer for the opposing stores, Winos LLC, Bushwick Liquors, Bentley's. With me are Mr. Bluecroft, who owns Winos LLC, DBA Henry's, and and Bushwick Liquors. Are you the owner? Yes. Right. Google Maps has since been corrected, and I submitted a map. There are 8 stores within 0.4 miles. You've seen this map before. We've been here many times. This is the area. This is Bushwick, and that's the store 239 feet away proposed by the applicant. And these are the 8 stores within 0.4 miles. I understand Commissioner Donahue's explanation about the system. But so we have the 4 stores that showed up in LAMP, but really there's 8 stores, and you don't have information from them. So I don't think you have sufficient data.
That's what he just described. That happens regularly.
I understand.
We just had an application for Manhattan that there are probably 40 within a half a mile.
Our proximity report lists 8 stores. And we go with the 4 unless it's a situation where they're all
exactly the
on
same
top of
distance.
each other. Okay.
In any event, we expect that the applicant's going to argue that a new supermarket close to where they are, which is very close to this gentleman's store, is just opened up. We've been waiting for that store for how long? How long you know it's going to? 3 years. Yeah, he's been waiting for a long time for the store to come. He's 239 feet away. I sent you a picture. I walked it to myself after the last time I was here. I went out there to get a handle on where these other stores really were. I visited his store. He has a lot of wine. I did note that other than that new supermarket that's apparently opened since I've been there, there's a number of stores, I sent you the pictures in my memo, that are just vacant, 3 o'clock in the afternoon on a Thursday. It's not like I got there early or I got there late. It's at the height of the day, these stores were closed. I don't know what you can tell about those stores.
Those stores are just vacant. I mean, it's been like that for years.
Yeah.
The property owners don't want to rent out to nobody.
So these stores are well suited to serve that new supermarket if that was the goal. I don't know if they're going to argue differentiation, or even the gross sales. We only have gross sales from 2 of the stores. It would be really helpful if we had gross sales from all 8 within 0.4 miles.
I'm going to tell you what I find more telling is that 2 of the 4 are bulletproof.
Two of the 8 are bulletproof.
Well, I'm worried about the 4 that I have in front of me.
And one of them, they have a buzz-in system.
How is that convenient for the public?
They can come in and handle the bottles, which is the whole
You have to
issue.
be buzzed in.
Yeah, you got to be buzzed in. Apparently, they have some safety concerns. But just based on the pure numbers, you know, even if you take away those 2 stores, you get 6 other stores within 0.4 miles that aren't bulletproof. Any suggestion that gross sales are higher doesn't take into account increased labor costs, increased inventory costs, increased rent. Your rent was what, up 72% over the last 5 years? So when the wholesalers raise their prices, you charge more per bottle. You collect more sales tax. The gross sales number is up. That's not, but the number of bottles you're actually selling is down because the area is diluted. Also, they're having a problem with so many stores selling wine in this area of getting the products as an allocation. So Mr. Woodruff can speak to that.
Basically, wines, we were able to get 3 cases of 3-case breaks. You know, producers we've bought for almost 10 years now. We're being offered 12 bottles, 6 bottles, which means, you know, when we could get it at 3 cases, we'd get it down to $20, meaning we charge $30 for the bottle. Now we're paying $24. Customer's going to pay $5, $10 more on that bottle just because we're getting 6 bottles, because all the other specialty stores being opened across New York are cutting into production that we're able to get. So specialty stores are becoming less specialty as more of them are out there. And ultimately, we're reliant on small winemakers in, you know, France, Europe, around the world that can't all of a sudden double their output. And like John was mentioning about the increase in gross sales, you know, you add 25% tariffs on French wine, European wine. I'm not gonna lie, wines that I was selling for $30 retailed for $50, and I was making less of a profit margin during this time. I know the applicant is also relying on internet sales, and let me also say that somebody who's been very reliant on internet sales, it's getting quite competitive out there. I spend $2,000 a month on Shopify Plus to try and have an advantage in terms of the e-commerce platform I have and the convenience I can offer to the customer on that. That's a whole new expense I started in 2019, 2020. And I know I had crazy sales in 2020. Pandemic was a very unique year, which was also due to the fact that Irving Bottle was closed for about 6 months during that year. So in addition to all the restaurants being closed, giving me that business, I also had one of my closest specialty competitors closed for a prolonged period of time during that. And then you quickly see 2021 and the trends in 2022. My sales are back to pre-COVID levels while I'm also facing.
Pre-COVID, you were at 500,000. Post-COVID, you're at 700 plus. You're the
not
closest
me. That's
store,
not
right?
me. No, I'm Winehouse LLC, Henry's. I'm Henry Bluecroft.
I'm Bushwick Liquors.
So I'm back to, I can't remember my exact numbers, but I believe I'm very close to 2019. And when you factor in the tariffs, my labor costs going, you know, I was paying $18, you know, roughly $18 an hour. I'm at 25. I don't have anybody under $23 an hour now, and that's the lowest wage. I have a manager. Also, I can't remember the exact date, but somewhere around 2019, 2020, I started to ship wine to more states. So that's giving me a larger potential customer base. And yet still I'm struggling because, you know, there's a lot of specialty wine stores opening across the city with websites and my customers come from I get inquiries from other countries. I get customers from other countries. So to suggest that somebody can't walk an extra 300 feet for a particular bottle of wine versus being able to offer that bottle of wine for 20% less because I would have a little less competition is a little tough for me. And, you know, I'm a little concerned going into perhaps a tighter economics, you know, period of time. And, you know, there's a little uncertainty ahead, and I feel like you did not approve a store that was applying at 601 Bushwick Avenue in 2019. That's kind of applying, and I don't understand what added convenience this new store would do. Any new buildings were there or, you know, near completion at that time of the other application.
Okay, can you wrap it up?
Yes, just 2 last things. Any suggestion that the 2 Broadway stores might be bulletproof is a justification for a store 239 feet from this gentleman, I don't think is really quite fair. There might be room for a open store over on Broadway or that corner of the map, which there really isn't that much. But right here, this gentleman's been waiting for 10 years. I believe he's a good licensee. I'm not aware of any adverse history. He's got an open store with floor-to-ceiling wine that can serve this supermarket. He's been waiting for it to have it pulled out. It's not inconvenient for the public to walk that very short distance to his store. And based on the number of stores, eight within 0.4 miles, and we don't even have sales for all those other stores. I don't think you have the information you need to conclude that the public convenience advantage would be served by adding this store here at this location at this time. Thank you.
Thanks a lot. Thanks.
All right. Well, the substance of my arguments is not just talking about the other people in the neighborhood. I'd actually like to highlight my applicant as well, because I believe what they're trying to do in this space is by itself incredibly unique. But before I get there, I will talk about the neighborhood. Chairman, you brought up a great point. 2 of the 4 closest stores are bulletproof. Also, one of these stores didn't respond to the inquiry from the Liquor Authority with respect to numbers, and we're not even sure it's still open. No one's been able to ascertain that fact, and that's store number 3, I believe. The gross sales numbers are increasing from all of these stores. You've heard about the increased labor costs, the tariffs, and all these other things, but that should be a constant because that's affecting everyone in the same way. Additionally, this is an area in Bushwick which is rapidly growing and has been for a while. You've heard about the fact that there was a store denied here in 2019. And before I get into talking about what this particular applicant's going to be doing differently in terms of store layout, product selection, things like that, I'd offer that there hasn't been a new liquor store opened within these 4 closest in almost a decade. The most recently opened store was Henry's, which was about 9 years ago. So they've mentioned the gourmet grocery that's come into the neighborhood. There's an all-female gym right there. And this particular location is in the ground floor of a building with 500 residential units above. That's about as convenient as it gets for those people. There's tons of residential development in this neighborhood. Many of these buildings that were approaching construction at the time you heard the last application have now been completed and are now pretty close to fully occupied. Now back to what my client specifically is doing in this space, and I'll let him explain it himself. But as I put in my papers, and again, I know you have a long agenda, so I'll try to keep it brief. We are thinking museum gallery style store where it will be wine only, by the way. The 4 other stores that you see there are all full liquor stores, including the store closest to us has a liquor retail license, and they have, it looked like by our accounting, more like 75% spirits, 25% wine. But be that as it may, we will have 0 overlap with that store. The only store where there might be any overlap at all would be Henry's, which is not 200 and something feet away. It's more like almost half a mile away, which is significant, as Commissioner Ford mentioned earlier, in New York City area, that's a long time to go. I'll let my client speak about the concept, which I think is unique, but the important takeaways of it are that the layout, customer experience will be incredibly unique, and the product overlay will be virtually non-existent.
So yeah, we really don't want to be a traditional wine shop. Like our ambitions are to be more of a kind of a cultural institution. We want to highlight education. We want to have a lot of classes, a lot of tastings. We want everything to be community-based. We have the landlords and developers are working with us. They want us to be very involved with their residents. We also want the store to be experiential. So it's going to be designed like a gallery. The selection is going to be very limited, and it's basically going to operate like a art audio tour. So we'll have QR codes next to the wine products. People can scan it, hear the story of each wine. So it's going to be more like a, Airbnb experience. It could be a date. It'll be an attraction. We're trying to attract people outside the immediate area. Yeah, so we definitely want to not just be a neighborhood wine shop.
Do you have some sketches of like your design? Because your square footage is relatively small. And you're talking about a pretty ambitious plan here.
We're designing it right now. I just had a meeting with the art gallery owner yesterday. We walked through the space. She thinks it could work. Basically, what we have right now is like a partition that takes away about 300 square feet, and the rest, about 700 square feet, would be used as the floor.
You have family members that have a liquor store?
Yeah, I've been
Where's
in
that?
it. My mother has a store in Bay Terrace Shopping Center in Queens. She's had it for about 17 years.
And what's the name of that store?
Legally, it's called Stella Liquors Inc.
Stellar Liquors?
Stella.
Stella
Her
Liquors.
name. Yeah.
Oh, you work there?
10 years.
He purchased the wine there.
So I'm trying to do something different. I really don't want to, do something.
I'm
that
excited about this record store. I was just recently talking to people about, I'm dating myself, but discovering bands going to, audio stores and record stores when we were kids, and
Yeah.
it's not like that anymore.
And Bushwick is like very alternative. It's gonna be welcome there. People are looking for a different type of experience and opportunity to like learn about wine. We're targeting millennials who have expendable income. All these new high rises are pretty luxury.
Is your store located, you're on Bushwick, are you like just about at the intersection with Flushing Ave?
Yeah, so Bushwick Liquor is right on the corner.
South of where you're.
South, so
They're more towards,
yeah.
Forest Garden, yeah.
Yeah, all those housing developments they serve right there.
But it is the next block.
It is the next block, yeah. But we could totally work with them, not have any sort of overlap. We definitely don't want to take business away from other stores. I know the dynamics of all that kind of the landscape of that.
The members ready to vote? Commissioner Fan.
All the surroundings in stores, even removing the COVID bump, is doing rising numbers. This is a relatively small store. I'm going to find public convenience advantage and vote to approve.
Commissioner Ford.
It is a pretty small store, and you are not going to do bulletproof, is that correct?
Sorry?
You're going to be open, not bulletproof.
Yeah, open.
Open and wine store only.
Like a gallery, very open.
I see the closest store, they did a sizable bump in 2020, like just about everyone did, but 2021 was down. 2022 was only through numbers through the spring, so the next closest store,
It's bulletproof.
like they went up a little bit, but again, through 4/22, hard to predict what it is. Third closest store didn't send any numbers in. I think just looking at the numbers, I'm not sure that I see a need for another one here right now, so.
Also, mind you, these high rises aren't completely full. So we talked to our building managers this week, and they said it's about 2/3 full right now. The pandemic kind of hurt their.
I understand.
Yeah.
But I know that we can factor that at this point, so I'm going to vote to deny at this point.
Chairman Bradley.
I'm going to vote to approve. It's a unique business model that he has. He's only going to be wine. It is a smaller store. The other stores, I get they had a big kick because of COVID, but they also do seem to be increasing even after COVID. And I just want to make clear, though, there's not going to be a liquor store here. So whether I'm here or the next person, I just want to be clear in the video that your business model is what got you approved. If that changes, then you got to go somewhere else, I guess.
All right. Good luck.
Thank you so much.
Thank you.
Next is 1496 Sushi on West 10th Street, LLC.
Joseph Levy again.
So the community board does not like your outdoor shed.
Correct.
What do you want to do about that?
And to
First,
that,
let's see if they're here. Can you just introduce him first?
Sorry, Stan Matusevic, I'm the Director of Operations for the group.
Okay, is the community board or anybody here in opposition? Okay, go ahead.
Just a quick note, the application before you is for an upgrade of license from beer and wine to full liquor. At the community board meeting, the sum and substance of the argument against was truly the outdoor space. At the time, we had been inspected by DOT and it was ruled to be fine. They had initially asked us to move the shed to bring it back into compliance, which has been done. They have since come back after that and indicated that everything was fine. The only issue was they wanted us to put the snow things in there, right?
Right.
So there was initially an issue where they said that it overlapped a period and the roadway shed was moved back into compliance as per the DOT.
So you're not blocking the bus stop anymore?
Correct, we're not.
And with respect to the restaurant itself, this has always been a small omakase, unique concept restaurant. And it had the opportunity to take over the space directly adjacent to it, which was a restaurant that had closed its doors. They were able to break through a wall and extend that area. And they'd like to offer their patrons an upgraded drink menu. The reality is, as you can see.
I'm going to vote to approve.
Okay.
Thank you.
Thank you.
Commissioner Ford?
I vote to approve as well.
And Chairman I'm going to vote to approve.
Okay, thank you.
Thank you very much.
Next is 1499 Burger Joint at MOYNIHAN Food Hall.
Joseph Levy here again.
10%?
The application.
Why is this here? Because of the 10%?
It's here because in the lease, it indicates that there are certain breakpoints that if the tenant hits them, they could share in.
But it's the first break point's at 4 million, right?
Right, they're
All
projecting to do like $1 million.
It's here for that, to make sure that you believe it complies with the food court advisory and
I do.
the restroom waiver.
Okay.
Yeah, and-
Donald, I think we're ready.
And just for the record also, the examiner asked us to sign an affidavit that we would comply with that, which is on file with the authority.
Commissioner Fan?
Yeah, right.
All right.
Oh, no, even if it does, it's 10% of total sales. So if it goes, if it doesn't kick in, you already got 4 million, it'll never hit 10% of total sales.
I see. All right. I'm good.
And-
I'm vote to approve.
Same here.
I'll vote to approve.
Thank you,
With
and
the
just
waiver?
one more note for the record.
Yes, with the waiver.
With the bathroom waiver, yes.
There are a number of these applications that are going to be coming before you that are almost standard form leases, so I don't know if there's anything you'd like to do about that, or if you'd like to hear them
Yeah,
all
can
here
we just
again.
not do that unless you see a major problem with it?
If those are the only issues, then we can have licensing board.
Yeah, as long as they're in this, I mean, unless there's a big supervisory issue, as far as the way they're operating, we don't need to see those.
And I can send the deputy commissioner a list of what's upcoming just to make sure that they're all accounted for.
Okay.
Thank you.
Next is 1508 Manny Marketplace, Inc.
Oh, I think he's representing all the licensing.
1508.
Which means he must have some kind of deal with the landlord.
Martin Mailer of Mailer Musemi. This is a request for reconsideration of a denial of a renewal. The licensee is not here to in any.
It's not a request for reconsideration. That was.
It's a request for a corporate change.
Well, I'm sorry. In a sense, there was a denial of the corporate change, and
Reconsideration was granted.
Yes.
And it was sent back to licensing. Now it's before the board.
I'm sorry. Correct. This is a request for a corporate change of an existing grocery store that's been in business since 1991. I stand before you on behalf of my client who's here. Do you want him to introduce himself?
No.
Okay,
Because I'm just like, you don't even want to see what I wrote down here.
Well, look.
How long have you been involved? Because this thing is a mess.
That's what I was about to
And
say.
the last thing I want to do, as you've seen already a couple of times today, is shut anybody's business. So I'm not going to shut his business.
All right.
But you need to go get this straightened out.
I did straighten it out, or at least I'm a Johnny come lately in that I've just filed what should have been filed
I mean,
a
it
long
kept
time
getting
ago.
messed up even after they got lawyers involved, which is not surprising, I guess.
I'm not speaking for other attorneys. I want to say that it is going to be done properly. He sells meat, he sells groceries, he sells fish, and he sells cheese. But in terms of being able to do this properly, no, he did not do it properly. But it is being done properly now. And I would ask that what was a licensee for many, many years remain a licensee. His father gave it to him back in 1991, didn't follow formalities, unfortunately died, so he can't stand here before you today to explain his motives. He did have an affidavit drawn back in 2019. I would ask that you please, please, please approve this corporate change to allow someone you've approved in 1991 to operate the premises on his own.
All right, Donald, I think we're ready.
Commissioner Fan,
I vote to approve.
Commissioner Ford,
I'll vote to approve as well.
and Chairman Bradley.
I vote to approve as well.
Thank you very much.
Thank you.
Good luck.
Next is, you're not next, sorry.
Oh, I
Marty.
always went back and forth.
Huh.
Oh,
I don't think so. No, not 1524. That's glass ceiling events.
That's gonna be. Can we take
Or-
2 minutes?
Yep. We're gonna go off the record for a brief recess. All right, we're back on the record after a brief recess. Again, 1524 Glass Ceiling Events LLC and ESK Management LLC.
Good morning, Commissioners.
Morning.
Oh, for the record,
Howard.
we did receive documentation last night. You guys don't have it. I believe you submitted documentation. And we also received another letter from Assemblyman Godfrey, but that was late yesterday that we received both that. I think reiterating.
Well, to as best I can take it, he was clarifying a prior letter to indicate that he didn't exactly say what the prior letter said. That a letter that indicated his approval wasn't meant to indicate approval.
Was not meant to?
Was not meant to.
Was not meant to indicate approval. Can I see that letter, please? Can you print that, please?
Do you have a copy of it?
We don't. If you have a copy.
Yes.
It was basically him saying he took away his opposition, but wasn't supporting.
Correct.
I'm sorry.
So he's neutral.
Yes.
I'm not.
Which makes it clear. And when you're already taken a position, you can't be neutral.
Well,
No, I don't need to say.
His previous letter, he withdrew his previous opposition, but he didn't state.
Previous approval.
Yeah. Approval was implied.
But he no longer objects.
Correct.
And what was in your submission?
It went on with the sound test, correct? It was
Right,
expanding upon
the
it.
sound test was done pursuant to the directive of the commissioners. And we had submitted a preliminary letter, but it took 3 days. It was done last Thursday, which was the date that the Gilsey House gave us. And the sound test was submitted, and it indicates that there was no audible sound detected in any of the 3 units that the Gilsey House selected that we should test them. But, no, excuse me.
We didn't see. Have your turn, don't worry.
May I proceed?
Yeah.
Thank you. So Commissioners, in pursuant to your directive at the last hearing, we engaged Criterion, who had submitted the original report, to conduct a test as you had directed when there was an event occurring, which we did. And 3 units were selected in the Gilsey House, and the testing was done. The report reflects that, in addition to the report that had already been submitted, that there was quote-unquote no sound audible from the event, and then it gives the apartment number in all 3 apartments. So not only was the testing done, it was done as the pictures that we have submitted reflect. The testing was actually done with windows open in the units, which is generally not the case, but in order to effectuate, in what was Criterion's opinion, an appropriate test, they opened the windows. And that was their report. There was an event that was occurring pursuant to your directive at that time. The event had 64 people in it. The capacity of the entire glass ceiling is only 74. The average event at the glass ceiling actually is only 50, but there happen to be 64 people there. And the only caveat in the Criterion report was that there should be a sound, quote-unquote, sound limiter in the acoustic system there that is already in place. It has been in place. And indeed, you cannot even increase the volume as a result of that sound limiter. So that's already in place. So we precisely followed the authority's directive and the commissioner's directive that was given to us at the last hearing. In addition to that, we had represented at the last hearing that we were going to enclose the outdoor space. And in that regard, I had represented to you as commissioners that we were going to do that, and that we were in the process of submitting plans to do that. We have now delivered to you the plans that were in fact submitted with the submission number to the Department of Buildings of the City of New York, which reflects our plans to do that enclosure, which is going to cost, as the chairman actually noted last time, approximately $1 million to do that. So those
Is
plans
that
are,
still a retractable roof, or is it gonna be now just permanent, you cannot move it?
the roof will be retractable, but
The new enclosure?
Yeah.
No, that will not, we will not, that won't be retractable.
It's not retractable. Are their doors openable?
The doors have to be for airflow.
Okay. But how does it operate? It's like a sliding?
It's a sliding, yeah.
Screen? Okay. Like a nano wall?
Yes.
and just for the record, Commissioners,
And are you keeping that closed, or is there like?
Yeah, the plan is to keep it closed, right? We don't want to disturb the neighbors. That's why we're building this entire structure, so that we mitigate the noise. The plan is to get that closed, but we do have to
Are there
allow
nano
airflow.
walls on both sides? Like there where if you open both sides, you basically just get a roof and like no walls?
No, it's a permanent structure on the outside. So,
It's a permanent glass structure.
Is there a sketch of it?
yeah, it's in your submission from last week,
It's
or 2 weeks ago.
Connected to the building.
It's a whole actual thing?
Yes.
Okay. It's this one, right?
Yeah. It is a plan what you submitted, yeah.
It's this same one.
No, that's actually, can I approach the
Yeah,
bench?
yeah.
So in the, that's what we have today.
I'm sorry, there's endless amounts of paper here.
This is the schematic that was submitted to the.
Oh, perfect.
So this is what you see, the wall, right?
Mm-hmm.
And then these are the existing. So this is the wall that's already free, that's already existing there, that's from the existing structure. And this would be to replace that. And again, as we reiterated last time, we're not able to do this small balcony due to FDNY legislation or code.
Right. Okay.
We've sent that to this, we've also submitted that to Community Board 5 as well.
No,
you haven't.
Excuse me.
Yes,
Let me finish, please. Excuse me, let me
Yesterday
finish.
evening, they had not received it.
So let me just, so number one, last week, as soon as it was
Okay,
cited.
excuse me.
We cannot have a side conversation.
I'm addressing.
It's, talk to the members,
Okay.
not among yourselves, okay?
Excuse me, my client is still speaking. You'll have your turn, right?
The commission asked me to respond to this.
No, I didn't hear that. I didn't hear that at all.
I'll just reiterate that, and apologies, I'm in not good health today, so I apologize. As soon as the sound testing was completed, we submitted the preliminary report. Every single time we have information, we submit that to CB5. We submitted as soon as we submitted to the DOB our submission, we got a jobs number. We immediately sent that to CB5, letting them know the jobs number. They can look up in the DOB system immediately using that jobs number. I also sent again this morning to CB5 the enclosed package that you have there, Commissioner Fan. So we've sent everything to
Yeah.
CB5.
What was in your submission to us yesterday? Is this, or there was a sound report?
The full comprehensive sound report
you
as
have a
well as
copy of that?
pictures. Yes,
Sure.
and apologies, because of the time compression.
That's okay, I understand. No, we'll try.
Commissioner Brand, at the end of each description is where it says, no audible sound detected.
Yeah.
And then it lists the apartment number. There were 3 apartments that were tested.
All right,
So,
which they told us.
and I just, for transparency purposes also, Commissioners, within 24 hours of our following your directive, we received a request that they wanted to do their own sound testing. Now, this is notwithstanding the fact that we've been offering that for 2 years now through the NYPD and the DEP. And the request asked us to turn off the air conditioning system to do the testing. This is what covers.
I read all that. I don't
Right.
need another.
Okay,
test.
thank
So
you.
I don't think any of us do. We have it. There's no, in my mind, the sound engineer you used is in here a lot. They're reputable. I don't see why what their motive would be to lie for you, as is their sound engineer. And
Right.
I'm not going to get into this competing experts.
I agree, Mr. Chairman. So accordingly, Commissioners, we believe that we have done everything possible. We are in closing. And the fact of the matter is the documentary evidence before you shows there is not a noise issue with this facility. And moreover,
Provided everything is closed.
correct, Mr. Chairman, yes, which is our intention. And we would not have gone to the extreme of submitting to the DOB if that was not the case. We represented we were going to do that. We've done that, and we expedited the plans in order to demonstrate that we made that submission to the Department of Buildings. We are in closing.
All right, thank you.
Thank you,
Let
Mr.
me hear from them now. You guys can sit down. Who are you, sir? Oh, you're with him?
Sorry.
That's all right. You can, the opposition can come up.
Thank you.
You
Thank
guys
you.
can sit. You don't have to stand.
Let me just mention, we've lost two members of our group from Josie House, Miss Van, Vivian Fan. Pam, I apologize, was taken ill, and one of our other members who oversees the glass ceiling took her to the emergency room. All right. On the July 13th meeting, the commission encouraged us to go back to try to negotiate and come up with an alternative that we could all live with. We worked through CB5, and we came up with a proposal that would require them, or the continuation of the tavern wine for a period of time, with the understanding that the evening hours on the inside area, the place that's already built, would remain closed. And that would give them time to then process the plans which CB5 has not seen before, perhaps this morning, and we have never seen, for the construction of this solution. And I just want to point out that while it is possible to file a plan, that does not indicate that it could be built, that it meets the zoning regulations.
Ma'am, we had this discussion last time, and I'm going to have it again very briefly. I am not going to make them build this thing and then ask for the community board input afterwards. Financially, it makes absolutely no sense. And I can put conditions on whatever we do here today that require them to build it or not use it. Either do not use the space or enclose the space. But what I'm not going to do is say, go spend whatever they have to spend, which is more than I make in 10 years, and then go to the community board and ask for their approval after you built it. That just, I'm an accountant. I know that doesn't make financial sense. So I get what I understand you're trying to be cooperative, but you have to actually think that no one's going to front that kind of money not knowing where the community board is. In fact, I can predict where you'd be. So that's not going to happen. So I think we need to go in a different direction.
All right, if I may just follow up on one point I was trying to make, that is the mere fact that something has been filed in the building department does not in any way indicate, excuse me, we've been down this road before, back in March.
But you're missing the point. I told you that if it doesn't get built, they can't use it.
How about they get a building permit?
It doesn't
This-
matter.
this
If
is
they
totally
don't build it, they
bogus.
can't use it.
They've done this before. Back in March of 2020, they came
But you
up-
didn't have me telling you they can't use it. I'm telling you that if they don't build what they're telling us they're building, they cannot use that space.
But
with alcohol, without alcohol, they can't for their business use it.
Excuse me, but they can, the existing construction allows the roof to be open and the sidewalls.
But what I'm
So-
telling you is their license is going to demand that none of that occur. If it does occur, at the end of the day, it will cost them more than it cost them to build it.
If I may-
And it probably will cost them their business.
I will move on, and I will discuss the basis of the sound testing that was done. It was done we have a report from our sound engineer with everything closed, with the roof closed and the doors of this, the existing glass enclosure closed. That has, regardless of the
Right,
fact.
which, if
I'm
they
sorry.
get the license, is how they will be operating. So that would be the.
No, and they may say that, but I think I'd like to now turn over to the actual.
So here's the premise,
actual
and
residents.
she's welcome to talk after we're finished. The premise that you're all operating on is not the premise that we operate on, because we're not allowed to operate on that premise unless there is a significant history showing us that, and we don't have it in our records. So when we say to them, you have to operate with this closed, that closed, everything closed, you're jumping to the assumption that that's not going to happen. Maybe you're right, maybe you're wrong. I can't jump to that assumption. It's not fair to them because we don't have a file that says they're doing that. Now, if they go do that, after I speak to her directly about it, then it's going to get really, really expensive for them. So to the extent that it'll be so expensive, they'll either stop doing it. If they don't stop doing it, then they're going to lose their license, at which point then you won't even have it there.
If I may, I would like to introduce you to the actual residents who overlook this particular, the way this is being operated with the Tavern Wine. And we'll start with Jamie.
Yep. Good morning. Thanks for listening again. I know you guys are probably tired of this case.
Whatever gave you that idea.
Yeah, exactly.
Love this.
But just, I hope it resonates with you how many people here show up and take time off from work, including ones with medical conditions, to try to be here, because this is very, very important to us. So this is not BS, okay? Let me just say, yeah, and I know you do, so thank you. And listen, the first time you heard this application, there were some strong statements made in terms of why it was a unanimous denial, right? And I do want to just restate a couple things, because, and I'd also like to show you a video that kind of drives this home real quick, because we have not been able to submit videos to your website. But my apartment, I live in 4G, is at the roof level, okay? So the noise complaint we'll come back to in a minute, or the complaints of noise and the sound test. I'll just address that in 1 second. But there's another issue as well that needs to be addressed. And we put this forward in our proposal. If they were to extend hours, because we're trying to be real here, we understand if it's closed completely, and that's the only thing that sound test really has shown, is that if it's entirely closed during a speaking event with 50 people, I'll take their word on the attendance, we don't hear it. Okay, that's fine.
So the record's clear that the number of people there was 56 customers,
Yeah.
eight workers. So we're into mid-60s now. We're not at 50.
That's fair. And they're entirely indoors. What I'm saying is I think the glass structure seems to hold the noise, right? And that's what that test is showing. What it is not showing is that when it's open, there's a lot of noise. And I'd like to just...
I absolutely believe you. You don't need to show me.
Okay.
I believe you. If it's open, it's noisy.
It's super
I
noisy.
do not deny that. And
Okay.
I'm not going to deny it at all.
Okay.
The roof should not be open. The doors should not be open. I think everybody up here agrees with that.
Okay. So then...
Am I wrong?
No, and the last time they came, we didn't say she needed to keep it closed.
Yeah, we did. No, they agreed to keep it closed.
They agreed to keep it closed. They proposed it. And I understand your point, Chairman Bradley, that you can't sit here and say, well, what if, right? I mean, if they violate it, you can put it in writing and be very clear, these are the conditions. So I respect that, and I know where you're coming from. There is another issue in addition to the noise and being inside, and it's not sure if you've been able to see this in some of these submissions, especially from me. My apartment is at roof level. So again, I can step out the windows right onto the roof right there. In front of my windows, they have placed in addition to HVAC equipment to support it, there's a big, huge walk-in refrigerator. That supports the operation. So any increased hours, or even today, right now, they can go up to 9 p.m. inside. Their staff is coming in and out constantly through a gate right in front of my windows, accessing the refrigerator, slamming it shut, dragging kegs or whatever else they put in there. And I hear that, but more importantly than the noise, I see it. And it is a security threat. Having people, imagine you're sitting there watching TV, eating dinner, whatever, at night, I have to, all of a sudden, I'm like, oh my gosh, what is that? It's somebody coming out right there in front of my windows. That is not an acceptable situation for me. So in this proposal, what we're trying to address is not only the noise and the indoor, if it's fully enclosed, but it's also address the security concerns. I don't know that I have a perfect solution in my head for exactly what that is. They could move the walk-in refrigerator or enclose it somehow, or put something with windows. We'd have to discuss that. I'm not asking you to weigh in on that, but that needs to be a stipulation because it's directly affected to these increased hours which you're being asked to weigh in on.
What is the stipulation regarding the cooler? What are you asking us?
I'm asking that their entire operation, they could, even if they enclose
Can I
it.
just clarify something?
Sure.
Security would mean that they can actually climb over and go into your apartment.
Yes.
That's not what you're talking about. They're actually like.
No, that's what he is talking about.
I am talking about,
That
they
they
have
can
direct
climb up a
access
building and go into his
when they're on the rooftop, and it's mostly staff, right? Because it's not the main public area of the venue, but we have pictures and evidence of people coming out there and smoking, even patrons. So if they come out there, they're right in front of my windows, and they are literally, I have a single pane of glass that is right there. They can just, they're not only looking in there constantly, so the staff knows everything about my apartment. And
Yeah, I
patrons
understand.
could
And
come in.
And your windows there are operable?
Oh, yeah. They're operable. All of my windows are operable, and no, they're not lot line windows. And even if they were, that wouldn't matter. They're there, and they are facing this venue, and that needs to be addressed as part of any solution, any compromise
This
here.
is why they had 8 o'clock last time. I mean, that.
Yeah, exactly. You stated yourself that this was reason enough to deny because, in my previous letter, I said, we have several windows that are directly exposed and fully accessible to the rooftop, and we have concerns that if there are hundreds of patients and are coming to this venue, many of them will be able to see into and have access to our windows apartment. That is reason enough to vote to deny.
All right, can we hear from the rest? We have
Yes.
to get through this.
Chairman Bradley, can I add one point to that to help him out?
Yeah, can you just let him speak for 2 seconds, please?
So I hear his concern. My name is Rajadash Aswad. I'm owner of the building. I will like to help on this matter for his security. I will raise the 6 feet wall on the border, the building wall, so that he does not have any issue of seeing anything or covering. Make sure that it covers all the building lines, covers his view on looking at people. I propose that you can put that into stipulation. I'm okay with that.
Okay, thank you.
That was a wall and black and
Yeah, I don't know how that's better.
That's what you're asking for.
We have
No, I am
received
not
those
asking.
types of proposals and threats before, so we are familiar with them.
Please don't repeat your previous, because you were here last time and we heard so if you have something new, certainly add it, but.
Please don't
Do I
have
need
any
to
side
introduce myself?
conversations.
Go ahead, ma'am.
Yeah. SLA members, thank you for your time. I'm Anna Mackey. I live at 1200 Broadway. I've lived there for 12 years with my husband. We now have an 8-year-old daughter, 2-year-old son. I'm opposing Glass Ceiling Events LLC as the venue stands right now. I'm standing, Chairman Bradley, Commissioners, not to argue the facts of the case because those have been in front of you for a long time, many years. Numerous CB5 resolutions recommending denial under the current circumstances, 2 separate administrative law judge 500-foot hearing reports under the same circumstances, both recommending denial, and your own prior denial of the same OP license under the same circumstances. So the facts are clear that the venue is not appropriate as it currently is for an OP license, and issuing an OP license under the current circumstances is not in the public interest. But I'm not here to argue the facts. I'm here actually to invoke your humanity, your courage, and your heart as you're making this important decision today. I'm here as a working woman and as a mother. A lot has been said as part of this application about women empowerment, and I have something to say to you about women empowerment. Women empowerment is empowering the working mother who wakes up at the crack of dawn every morning to get her kids ready for school before she goes to a long day's work. And that's not possible without enough sleep. And I'm asking you to empower that woman, empower us, because that's whom you should be thinking of when you make those important decisions. Empower my neighbor whose husband passed away 2 years ago at the age of 42 and left her, a young widow, to take care for herself and their 7-year-old son. She, like all of us, is terrified by the prospect of you granting this OP license today. What would happen to her and her child's quality of sleep and quality of life? That's women empowerment. Empower her to get the sleep she needs so she wakes up every morning, faces her reality, and keeps going for herself and for her fatherless child. That's women empowerment. And empower Vivian Pan, my neighbor who was here, but she had to leave for an emergency health issue. She has sent you numerous evidence from her bedroom window. Her husband is bedridden. She is charged with the important task of caring for him 24/7, while herself undergoing cancer treatment. Empower her. This is the evidence, Chairman Bradley, that if you haven't seen, 2 500-foot hearing reports and Vivian Pan's numerous videos and pictures of the indiscretions of this same applicant disregarding your own stipulations. I'm going to hand this to you.
Thank you.
We're asking you to look at us, see us. Don't brush us off as too small or too unimportant, because we are the faces of the hardworking New Yorkers whose interest you've been charged to protect with this process, not the interest of a single party whose main motivation is their own profitability, and not the party who has time and again disrespected your own stipulations. Have pride in your own authority. You see the evidence before you. They got their wine and beer license. That should have been their happy place. They should have been happy with it. But it's not enough. And I'm telling you, should you issue that OP today, we'll be back before the blink of an eye for more hours and more events at our demise. And don't tell us, Chairman Bradley, that our own recourse is to come back and back again and fight this when we issue the OP. I've lived in the neighborhood long enough to remember Prana, that event venue, how many years those neighbors fought for their sanity. It took years. Don't tell us that's our recourse. Don't tell us it's our recourse. You have the power in your hands today not to issue that OP, and you have the responsibility to. And don't tell us that the single sound meter reading the day after Yom Kippur at a curated event is the only thing you're going to take under consideration when you make that important decision. You told us you know how the sound meter game is played. Don't play us. Don't let us be played. We're real people with real people's lives. And you, Commissioner Fine, last time you said, you know that the type of energy that comes out of an event packed with customers, having their drinks, enjoying their conversations, that type of energy transcends meter testing.
Ma'am, I got to wrap it up because we do have a lot of other people, but we're now getting into factual stuff that you indicated you had no interest in getting in. So if you could just wrap it up, we do need to hear from the other people.
Thank you, Chairman Bradley. We're all tired of this. And I'm asking you to not tire to do what's right. We're all tired. I should be at my work, being productive and advancing my own career as a working woman. But we all showed up to tell you that the decision we're going to make today is important and impacts real people's lives. Do the right thing. The facts are there. This is not an approvable OP as it stands. And I'm asking you, we're all asking you, have the courage, the heart, the compassion to do the right thing and not issue that OP. Thank you.
Thank you.
Good afternoon. My name is Hillary Foyer. I'm here as a member of the Gilsey House. I have 2 small children, 4 and 5, and 1 on the way due this spring. I'm also here representing the board. I'm an active board member. To this day, I was just emailing with the president of the board. We've received nothing from the glass ceiling, nothing about proposed plans, about doors, anything. We've heard nothing. So that being said, I'm here just representing the building as a mother of 2 small kids. Our windows face north. We hear the noise. I have to go up and turn my children's noise machines on louder and louder until they cease around 9, and then I can turn them down so that they stay sleeping. And I also am here just to represent the emotional distress this has caused for our building. We're the little building that could. We're up here fighting the good fight. We're doing all that we can. We've also done our own sound testing that proved after Yom Kippur wasn't necessarily an accurate event maybe to access, but we're willing to do the work, pay the money, and do more sound testing to prove that what this is doing to the quality of life of our residents. And again, we haven't seen plans. We don't know anything about that. We, as a board, we're open to discuss that, and we would like to if we would get the information. Thank you.
Thank you.
Am I able to just say something about that?
Not yet, no. Hey, who's next, please?
Hi, my name is Jennifer Chang. I'm a resident of Gilsey House. I think the issue here for you guys to decide, which you have spent a lot of time, is profitability in this particular woman's pocket, as well as against the well-being of all the people living in the building. They think by enclosing the glass structure that there's no more noise. As my neighbor, Jamie, has indicated, there is refrigerator, there is the doors keeping open and closed, keeping it closed. So it is not a fully enclosed structure. And their response, bullying, build a wall, block the view. This is the type of behavior that you see here in front of you guys. Can you imagine the behavior they'll have once they have the license? There is already a history of them not fulfilling the stipulation that is put on the beer and wine license. And I'm asking you guys to put this issue to bed because it has caused, as Hillary has explained, a lot of distress to our building. Thank you.
I'm Kim White. I've been in the building for 12 years. I'm the mother of 4 children. I have a party wall that overlooks the property and we all know what loud music does. It carries through the old wall that we have, and it's noisy and it keeps me up. I'm a teacher, and I just ask for my mental health and my physical health that you please don't grant this license.
Thank you.
May I respond? Let me just ask one more question. Sorry, before I was asking you for a sketch of what you plan to build. Do you have a sketch?
That is what we're building, right?
No,
there.
what you gave me is a
Oh, I'm
floor
sorry.
plan.
I'm sorry.
It's not a sketch. Like, I want to see if you have like a picture of what you plan
Like
to
a
build.
3D rendering?
Because now he's talking about building
No,
a
no,
wall
okay,
in
so
front of
let's,
someone's building,
yeah,
is
so
like-
let us, I've been writing notes, so we can.
No,
Hold
Can I walk
on.
there to show you what I was talking so you can
So,
be clear?
can I, this has become very, very emotional, obviously. Are you coming?
No, you gave it to me already.
He's not talking about building the wall.
No.
Okay, does this sketch?
No, she's asking for like a 3D rendering, which we don't have, which we can do. But we provided it everything.
This is a walk-in closet, and I was just going to raise this wall so he doesn't see. This is my building wall, my building light, not touching the building. I was not touching the window or anything. I'm just trying to manipulate every word we say, something. This is the what you call the walk-in that goes here, and this is the wall I was again, so he doesn't see people coming in and out. That's why I was proposing that you building wall on his window. No, I was not doing it. Yeah. Yeah, exactly right. Maybe.
But I don't understand how you build a wall.
My building wall is like this. So on that I was trying to raise. It's my building wall going like this. On this is my wall. On my building. On my side.
Okay, but then
Their
what it would
building is
look
away.
like from his
No,
side?
their
Yeah.
building is away. My building not touching this.
How many feet is it?
Like 4 or 5 feet.
That's what I'm telling you, though. Somebody would have to jump from the
Yeah.
building to the window to get
Yeah,
into the
4 or 5 feet.
Excuse me, we've been through this before.
Folks, we're not
you-
getting this
you
on
need
record with you.
to go back to the podium
Okay,
to
okay.
speak.
If they don't, I'm just trying to help those people.
Sir,
I get it. All right.
So let me just add a few comments. And I don't know all the residents' names. We were instructed by their attorney that we were not allowed to approach the Gilsey House at all. We were instructed by CB5 and the SLAP committee that we were not to have no contact with Gilsey House, that everything must be directed through them. Hence why we continue to reiterate, everything that we're submitting is through CB5.
Listen, I get, if you tell me you submitted something,
Yes.
you're not gonna come up here and lie directly to me.
Exactly.
I get that. It just means that maybe they didn't get it yet. I understand that.
Yeah.
And I'm not, as I said, I'm not that concerned that they see the plans of what you're going to build, as long as I see them and they see them. And that if we make this decision and determine that you have to build it, then you're not using it unless it's built.
That's
So,
fine.
but that's my point. So this back and forth and you being offended by it, you guys are wasting way too much time being offended by what they're doing. I mean, ask for it. If they refuse to give it to you, then tell me about it. But she has not refused to give it to you. But
I have the refusal.
they've now told you that they sent it. I don't know that she would come up here and lie directly to me about it because it wouldn't get her anywhere.
She said that she submitted it to CB5.
I get it, but everybody's using lawyers here, and you don't know when they're talking. You don't know when your people are talking to lawyers. She doesn't know what her lawyer did. There's too much people getting wrapped up in whether they're being, I guess, getting offended.
Excuse me, I'm not offended. I'm not. What I am telling you is we made a good faith offer.
You need to speak to the microphone. Ma'am,
Can
you speak to the microphone?
Ma'am, I read your offer and I told you why it wasn't acceptable to me. I am not asking someone to build and instruct a structure that then you are going to determine whether it's suitable for you or not. That's not possible.
If I may respond to that, we would like to see that these plans clear the Department of Building before you issue the OP, because you had a colloquy.
But ma'am, if
with
they don't
Commissioner
clear,
Ford, you had a colloquy with him, or he said, well, just issue the OP and we'll see if it works. And you turned to him and said, we can't withdraw the OP. What we are suggesting.
But what I'm telling you is I don't care if DOB approves them. If DOB doesn't approve them, they cannot use the space.
But they still have the OP.
But inside, period. I'm not telling you I'm going to get it. I'm just telling you what you're asking for is not realistic.
That they open the roof in the way that it is.
Which would be what? If I tell them that the place has to be closed and they open the roof when they're having a party, what would you call that?
I would call it not covering.
A violation.
Yes.
In which case you would bring it to us, I'm sure, immediately. I would send investigators in there, and I can guarantee you that that would never, ever happen again, or they will not exist.
Can I just clarify that the roof isn't retractable on the new structure?
How about the old structure? It's retractable on the existing structure. That's the point we're trying to make. And the sidewalls are open.
But you see, once again, we're going down a road where you're speculating illegal behavior. That's not the way we operate.
Mr. Chairman, may I address?
Yeah.
I'm sorry.
Hold on.
I think it's
Hold
my
on.
opportunity, sir.
Hold
Certainly.
on. Okay. There's a recording of all this, all right?
Yes.
So we asked those who want to speak to go up to the podium so the microphone picks it up, okay?
Right.
We can't have everybody yelling, all right, from different parts of the room.
Right.
All right, so hold on. Let's see who the chairman wants to recognize first, okay?
Go ahead and speak. Folks, will you all go sit down? I will give you another opportunity.
Mr. Chairman, just for the record, I want to be clear. We have done everything that you have asked us to do. The documentary evidence before you reflects the results of the sound testing. It shows, and by the way, I have a letter from another resident in 8G. I didn't want to get involved in apartment by apartment and who says what. I felt, and you agreed, that we needed to have a professional and a reputable company conduct testing. We did that.
I want the record to be clear. You're talking as if I did that.
No.
No, what I'm saying is
Right.
Commissioner Fan asked for that information,
Yes.
and she got it.
Yes. And
That was not, we delayed this in order for that to happen. I think her point was in
Don't throw
hopes
me
that,
under the bus.
no, I think that the point was in hopes that there could be some level of agreement. It was clear to me from the beginning that that was never going to happen, but she tried her best to do that.
And I think a condition precedent also, Mr. Chairman, was we had to have an event going. So it would be an actuality of what actually goes on. And because again, this is not a nightclub with dancing and partying. This is a place where folks are assembling and networking. And the pictures that we have submitted to you reflect that as well. That's what occurred at the event on that day. So the documentary evidence reflects the noise issue. As I said, I can submit letters if you prefer from residents that say to the contrary. But in addition to that, this is, we have gone to the length to be good neighbors, to agree to enclose. I agree with you, Mr. Chairman. We're not suggesting anything other than we're enclosing. We didn't spend all the money that we did to have plans drawn and submit to the DOB. We are perfectly comfortable and agree with you that this has to be enclosed. and that if it's not enclosed, we can't operate. So we're not up here making representations. Every representation that I've made on behalf of my clients has been fulfilled, including getting the submission into the city. So I appreciate the passion, but that is being exemplified, but the record speaks for itself here. The noise report speaks for itself here. We are in closing. And we are asking simply to ensure that inside we have the ability to operate till 11 o'clock, outside when we are not enclosed only to 8 o'clock, when we are enclosed to 10 o'clock. That's what we're asking for. And I don't believe that that's unreasonable. As I said, we're not a nightclub. We don't need to stay open till 1 o'clock, 2 o'clock in the morning. This is a place of assemblage of folks that are networking in a principally all-female networking environment that has been created. And we simply ask that we be granted this, and we understand that if we don't comply with what the restrictions are, that we are going to possibly suffer loss of license, significant fines. We're prepared for all of that. We're not up here, as you've indicated, Mr. Chair, making representations that we intend on violating or spending $1 million to enclose the area in addition to what's already been spent to build it, to violate it and lose all of that money. That's not the idea here. And we've done everything that we can do to be good neighbors. But as you said, Mr. Chairman, we cannot build something and then be told after the fact we don't like it. Thank you for listening to us. We appreciate it.
Ma'am, you already had your chance. Someone else who has not spoken.
Ms. Luzio has.
Ms. Luzio has also spoken. I do want to mention one thing, that it is, you turned down the same venue for an OP previously.
Ma'am, you've
Nothing
already
has
said this.
changed.
You said that already.
So I want to
You have said it
reiterate.
twice now.
Yes,
All
so
right,
I
we
want
got
to
it.
reiterate that the compromise we're offering is while they're enclosing their outdoor space,
I've
that
already read the
they
compromise.
get 11 p.m. indoor under their current license. But we're not here because of our opposition. We're here to solve a problem they created for us, which is they built an inappropriate venue for an OP license as is.
Ma'am, there's other people that need to speak. Thank you.
And Ms. Luzio.
I just have
You
new
will get the
information.
last words.
Thank you.
I just have new stuff that I didn't get the chance to show you, okay? Because
go
Commissioner
ahead.
Fan, you asked the proximity, okay? I just want to show you a photo. This is from my window, okay? This is the walk-in.
Can I approach Mr. Chairman?
Yes,
so I can
look,
see
yeah,
this?
yeah. We have that picture. sir.
Have that
We have
picture.
it.
Okay,
Yeah.
I just want to make a question. You asked how far the wall is if they were going to build something. It's literally right there. So
Yeah, we
there's-
have that.
Where would the wall go, based
Well,
on what
he
he
was
said?
suggesting, it sounds
On
like
my
a
wall.
his parapet wall, which is directly in front of my window. So
Fine,
there's
on-
no gap.
On my parapet wall, if there is a gap, on my parapet wall, nothing touching the window, nothing touching the other window.
To be fair, there's no gap in these, there's a gap in other parts, there's no gap in some parts.
But in front of you, there is a gap. So
No,
that's
no,
not
no, this isn't, there's no gap.
Okay, all right.
Okay,
folks,
anyway, sorry,
Please
the
don't
one other
talk among
thing-
yourselves.
All
And
right,
could you
I
go up to the
understand.
podium?
Okay,
please?
okay,
The
thank you.
other thing I just wanted to dispute is, this is a video showing, this is not women's empowerment, this is them serving out at 8:30, outdoors. It is not an event, this is when they're open to the public. This is what we're concerned about. Measuring sound during an event is planned with a microphone, look at all the people there.
No, but here's
You
the
can
point.
show it to him.
Here's the point.
show it to
If
him.
that, see, we don't, if that was, did you send that to us?
Well,
Not here.
Well, you don't get, okay, yeah, go
No,
ahead.
what I'm saying is the proper thing to do is send that, and I know we got complaints, and the complaints are being investigated. What that means, ma'am, sit down, please. What that means is that we're investigating, we're sending investigators in, and if that's going on, there is going to be, especially after all of this, very, very large penalties.
I understand, this was submitted over a year ago.
And Chairman Bradley, it is recorded
Over a
from
year
where?
ago.
Was it recorded from the venue or outside the venue? That is the thing.
No, I'm not worried. I'm worried about
If you're
if it's
recording inside the
after.
venue-
I'm worried about if it's after 8 o'clock and they're outside. That's what I'm talking about.
It is after 8 o'clock in their
No,
video.
recorded inside the venue, we don't know. It is what he
Right.
says, she says.
We're not going to
Yeah,
try that
yeah,
here.
when-
I get it.
You know, it's timestamped.
Now, ma'am, you want to go ahead? This is it.
That's my last, There has been a lot of personal attacks today.
That's for sure.
I'm just trying to run a business. That's why I'm here. I've been trying to get this license for 3 years. We have, from a future perspective, we are trying to be good neighbors. We have continually tried to work with CB5 and the SLAP committee and the Gilsey House as a representative. We've been told multiple times to work with CB5. Future state, we are spending the money to enclose. Future state, we were closing at 11. We would even do a stipulation that we will never go for increased hours. 11 p.m. We're running a restaurant and networking. And to the comments around women's empowerment, of course, we're welcome all genders. But given the name of the glass ceiling and what I do at Luminary, there is a nice correlation. We really just want the opportunity to run a fair business. We have come back to you time and time again after every time you've asked us to do something, and we've done it. Literally, the letter of the law, we have done every single thing you've asked. And I'm just asking for the fairness to be able to run this business under your stipulations. We understand all of that. But I'm not here to talk about profitability. I am a business person, absolutely. I invested over $5 million into these two businesses. I want the same right as every other business owner in New York.
Okay. Thank you.
The members ready to vote, or do you want to hear?
You can come up, come on.
I listened to the June hearing online, and I went up after that, a few days after, and I filmed, which I sent you. And there are 5 violations in there that they claimed that they were that they never violate. And it's in this very short little video. I also met the manager who said, go to my other club. I'm the manager of this club. We don't have our liquor license. Go to Elsie. It's a rooftop bar. It's not empowering women. If you see the videos, there's no women in it. They're young people in their 20s, 30s. It's noisy. We all know what bass does to a wall and to floorboards, and that's what I oppose. Thank you.
Thank you.
If you have women there, don't you think men might show up? I'm just saying, you know, I don't think you can say that it can only be women there. That doesn't make sense to me.
She just addressed that to her. She said we invite all genders.
Right.
Yes, ma'am, you're the last one. There's no more.
I think the point is very clear from the get-go. The space is not appropriate for a venue like that. You guys saw it. It's been years. They go back and forth, asking for exceptions. It's exception to the rule for which that you guys are deciding. And she can talk about all the money that she spent. Why? To make more money for her. A business is entitled to make money, but you also have to put public interest in mind. And we are the public who are opposed to this, and there are rules that needs to be followed. Chairman, you said, you know, if they violate, they'll be shut down. There'll be more problem. What about the violation that has already happened under their beer and wine license? Nothing has been done.
I don't know. I will find out, but that if it happened, then there will be repercussions.
And what's the
I'm sure
repercussion?
it's being investigated or it has been investigated. But we have heard all of this again. If you have something new, please add it. If you don't, we need to vote.
Okay.
All right, the members are ready to vote. All right, Commissioner Fan.
That's up to you. that's fine.
Yeah. Okay.
This is certainly a very difficult case for our board here. I really appreciate all the effort the residents have made to be here and to continue to engage in this process. I feel for you. I understand. It breaks my heart that this is happening to your homes. I mean, this actually really is emotional for me because I live in a building very similar to yours. Easily someone can go to the rooftop next to me and do the same thing to me, and so I feel you. Their building is zoned for commercial, and so they have there's a landlord here who's really actively participated, who's actively trying to adjust the space for his tenant and for you guys, and so I feel like there's something to hang our hat on. So I'm voting to support the OP application because then I can be part of the conversation about setting the terms limits. And so here they are. I'm going to vote to approve with the following conditions. As Chairman said, everything will be enclosed. Everything will stay closed. This license will not be issued unless we see the DOB approvals of the actual structure being built. Is that sufficient, Tom?
So until it's built or until it's approved?
Until it's, no, I mean, they can't use it until it's built.
Well, I mean, they can operate under their existing license.
Yeah, I know.
So what I'm
it
talking
doesn't
about is
switch the OP until the thing is built.
It's built.
And that CB5 has actually said it's built, it's good to go.
And to the community
I think
board?
we can get a letter from the community board to say that
Built.
it's built.
Period. I don't want any
Yeah, it's
opinions.
built. Yeah. No
Okay.
opinion, just it's built. And then we can do the transfer.
No, that takes forever. Yeah, and to be clear, that does not mean that the C of O needs to be issued.
No, we just need a letter from the CB that.
Yeah, but the CB should not be saying, we're not doing that until the C of O is issued. We are not requiring applicants to give us COs for obvious reasons, because in New York City, it takes 3 years to get one. Now, if New York City has a problem with them using it, and you folks can get them to act, that's fine, then New York City can enforce it.
Can I ask a question?
Hold on, she's not done yet.
Oh, I'm sorry. I'm just confused.
I'm going to, the premises will have recorded music only.
Background recorded.
Background recorded music only. No third-party promoters. No dancing, no DJ, no live music. 10 private events a month. That's 120 for the year. Security guard as needed, managers as needed. After you build the structure, how many tables are outside?
There are, I believe, 2, 4, 6 couches. They're not, and then about 4 two tops. So they're not tables.
So you're
they're
talking
lounge
20
chairs.
people?
About 20 people. 20 to 24, I think that's in the application. Seated.
These are just like high cocktail type tables?
There are about 4 two-top high tops. They're
Yeah.
like for dining, and
Right.
then there are 2, 4, 6, I think 6 or 8 couches, where during the day people kind of sit and work.
And the hours will be extended to 9 p.m. outside, 10:30 inside.
Commissioner Ford?
So I'm good with all of that as well. I just have one question, so I'm clear about this. The OP license, change in classification to an OP becomes effective when?
When the structure is built and we get a letter from the CB5 saying
Yeah. It'll be,
that
it'll be
it's been
condition,
built.
it'll be a condition of approval that we get the letter from the community board.
Okay.
And just the change of hours only starts when the new license is issued.
But inside structure, can we have it now? Inside.
The members just voted that.
I'm gonna address that. I think it's okay to give them the later hours, as CB5 has said, that it's okay to 11 o'clock under the existing tavern wine. For now. I think when they get the full OP, then they get pulled back.
I would say there's no application actually before the members to
extend
change
the-
anything with the wine license.
Okay.
Is there enough? Can I ask a question? I'm sorry.
The members are,
Members are
Wait till we vote,
voting.
and
Once they
then we'll
vote,
clarify.
then we can ask
So
questions.
what's your vote? This is the longest vote in the history. Come on.
Yeah. I'll just agree with Commissioner Fan's stipulations. Make it easy.
And Chairman Bradley.
I will do the same.
All right.
Now you can ask your question.
Yeah, I can't, it's hard to hear.
So Tom, can you read out what this is?
okay, so the on-premises liquor license is approved subject to the enclosed area staying closed. Windows, the license will not be issued until we get notification from the community board that it in fact has been constructed. Recorded background music, no promoters, 10 private events per month, security guard and manager is needed. The hours are 9 p.m. outside, 10:30 p.m. inside, and that's for the liquor license, not for the wine license.
So you're still under the same restrictions you have been undergoing until that thing is built. And just to make clear, the roof is to remain closed. All doors and windows are to remain closed under the new thing too.
So you're
And now
correct.
that we have discussed this for approximately 3 or 4 hours over the course of time, there's not going to be any leeway. So they send videos in, I send investigators in. If the investigators confirm the videos, it's going to get really expensive.
Tom, I believe there was no dancing as well.
Correct.
Yeah, well, I only, they didn't ask for
They didn't ask for
dancing,
dancing.
all right, so I didn't include that, but yeah,
Yeah.
anything you didn't affirmatively ask for, you're not getting.
All right. Do you have another question?
Can I ask, so
Yes.
I'm just confused, so even inside, because that's still gonna remain closed, even while we build the outside, are we able to have liquor?
No. Set the
No, I-
parameters. And the liquor doesn't start till the outside is done.
But that could, because of the DOB, that could be months and months and months and months and months.
Yeah.
I think that was her point.
But
But
that was
I don't want to
also
speak.
your
with
point,
her.
right? I mean, you guys are planning to enclose this thing.
Of
so
course,
enclose it.
but we also have asked if we could have liquor inside because we've already done the noise testing. The biggest issue is that outside, we're gonna do that. We've submitted it. We have expediters, we're working on that, but I'm also at the mercy of the New York
You
City.
wanted us to give it to you before you built it. That's what we did. That's as far as we can go. I think
Okay.
it's a fair
And once we get
Place we landed.
So once we get DOB approval.
DOB approval on the structure.
Once you build.
Entirely.
Yeah, of course.
So that goes against what Chairman Bradley said.
No,
originally.
I said, no, she put the parameter in there and the thing has to be finished.
Yeah, well, after finishing, once we DOB, the inspector passes it, and we send you, we can send you.
I'm gonna repeat it again,
Yeah.
okay? We need a letter from the community board saying the structure is built.
Okay.
Not DOB sign off?
No.
We need a letter
I made
from
it
the
clear, and
community
I'm gonna
board.
make it
Okay,
clear
yeah,
again.
got it.
DOB gives you a certificate of occupancy. In New York City, the word that we get is that's taking upwards of 3 years. So we have stopped asking all applicants, not just you, we have stopped asking all applicants for certificates of occupancy. If New York City wants to enforce the fact that you can't use the building without a certificate of occupancy, that's up to them. And therefore you can't use it.
And we're not reaching out to the community board.
Got it.
That's on you,
We will
okay, to
reach
get that letter.
Thank you.
Thank you.
Thank you so much.
All right. And to clear more people out of the room, the next item called is 1521 Sheep Shots CROSSBAY Inc.
I have to go. Use my trolley.
So they're not all here for this.
They're here, but I guess they're not coming up to speak.
What is this? What numbers?
Are you all here in the back for this?
Yes, you're.
If you're all in support? All right, put your name on the record.
Mr. Chairman, Commissioners, Kerry Katsouris for the applicant. The principal is Eva Serrano. As the board well knows, my client's license was canceled a year ago.
All right, I'm gonna stop you there. So can every one of you get in line and just come up and put your name on the record, please? Don't say anything else. I get you're all in support. If you're not in support, say you're not in support. But other than that, I get you're in support. Mr. Katsouris, will you get out of the way there?
Yes, Judge. Your Honor,
Nothing
may I submit some papers?
Yeah, go ahead. Come up, give your name, and just say I support.
You know there's a
Richard
deadline.
Lynch, I support.
Well, that's up to you to get him ahead of time.
Hang on a second.
What is all that?
Go ahead, keep going.
Go ahead.
Louis Abreu, support.
Fiordalisa Abreu, I support.
Samantha Lopez, I support. Jennifer Altador, I support.
Joanne Freitas, I support.
Ruben Delgado, I support.
Jason Santana, I support.
Laura Lorme, I support.
Imani Serrano, I support.
Douglas Pulido, I support.
Angelica Roca, I support.
Priscilla Dilone, I support.
Elizabeth Abreu, I support.
Christina San Antonio, I support.
John Hawkins, I support.
Smuquan Bostic, I support.
Samantha Giafolo, I support.
Angel Ortiz, I support.
Amanda Pacheco, I support.
Julio Ramirez, I support. Joven Padilla, I support. Ren Sukram, I support.
So who's running Ozone Park now that everybody's here?
And I'm assuming you're all over 21, right? Just asking, all right. Just
Wait,
checking.
so how many of you guys are customers? How many are employees? How many are family members? Can I see employees and family members?
All right,
Okay.
fair enough.
Mine would be here too. All right, go ahead, Mr. Couture.
Mr. Chairman, our client has been working in the community and has been for a long time since she's been closed. She's kept the store. She obviously has not been able to open and serve liquor. She's made arrangements with the landlord, who's been patient with her. Two bars that were in the neighborhood have closed. This is the only bar tavern, upon information to believe, that's open within a 10 to 20 block radius She's learned from her mistakes. They were basically COVID violations for which she was fined heavily. She's trying desperately and has done
So
everything
let
she
me just
could.
stop you there. So in July of 2020, those were COVID related, right? The ones that she paid 35,000 for, that was COVID?
Predominantly.
And then the second one was in November of 20, and those were also COVID?
Yes, Your Honor.
And what does she want, other than the license? Like, what are the hours?
The hours, what are your hours?
12 to 4.
And what kind of music?
Background.
Background?
Jukebox only.
No dancing?
Nope.
There's no room for dancing.
All right, Donald, I think we're ready.
All right, Commissioner Fan.
I vote to approve.
Commissioner Ford.
I vote to approve as well.
And Chairman Bradley.
And I'm going to vote to approve as well, but I want to make clear for all those other representatives that are now going to come in here with people with history similar to hers. She's got about 12 violations, all for COVID. We recognize here, since we wrote the regulations, how difficult it is to abide by them. She obviously paid a significant fine and lost her business as a result of it, so I'm willing to give it back to her. So I'm going to vote to approve, but people coming in with police focal point and things of that nature need not apply.
Thank you for
Good
your
luck.
courtesy.
Stay out of trouble, please.
Thank you. Good luck.
Do you want to take a brief recess, Chairman, or call the next person?
Did they all
We're gonna
unlock the door? She doesn't want me out there.
we're gonna go off the record for a brief recess. We'll be back shortly.
Donald, it's not every. Rock.
All right, we're back on the record after a brief recess. Next is 1541, Carl Place Wine and Spirits, Inc. It's a request for a reconsideration, so.
What number is this again? I'm sorry.
1541.
I'm sorry.
Good afternoon, John Springer for the applicant. With me is Mrs. Patel. This is a recon, so I guess we'll go first, if that's okay.
Yes.
I watched the hearing, actually, I was here. We, of course, want you to reconsider your vote. We think you really didn't fully address or even address it in your remarks, the elephant in the room. The only reason that we applied here was there was a 9,093 square foot store very recently in the same plaza with no supermarket. And the applicant applied for 1,980 square feet, a 78 reduction, and a supermarket's coming in, an Aldi's. The landlord told you in the record that Stu Leonard's moved because they wanted to be near one of their supermarkets and they can only own one store. I suspect that if they could own more than one store, there would still be a store here. When you mentioned the numbers, but you didn't really talk about them. Chairman Bradley talked about 14 stores within between 2.5 miles, including the Total Wine 1.4 miles away. Well, right, when Stu Leonard's were there were 15 stores within 2.5 miles. We're just replacing that store, much smaller store. When you approved Total Wine in 2016, there was a 9,000 square foot store, 1.5 miles.
Mr. Springer, you're not arguing, are you, that the conditions today are the same as they were in 2016?
In terms of the number of stores, I am.
No, I mean overall. I mean, there's, as you're aware, there's several factors that go into us approving or denying a liquor store, and obviously they change with time.
And this board didn't address any of them in their no vote last time, and so we're seeking clarity on that.
Well, I would imagine, I'm assuming we don't have a written decision on this, that every reason why it was denied would be in the written decision. You're also aware that what we talk about at the board is not the limit of what the written decision is. The board approves the written decision that goes out, which explains the reasons that we've denied.
So you're gonna add stuff later?
We don't add anything. There's a process that goes on that you're familiar with. That's all I'm saying, is that all your arguments up here are rehashing what we've already talked about.
Okay, well,
You're telling us we were wrong, but that's not what the reconsideration's for. It's to tell us what we missed.
Well, we're required by law to ask for reconsideration.
Okay.
No, Chairman Bradley, I didn't get to speak to last time. It was too late, you mentioned, before you vote. I didn't get a chance to speak.
I have never told anybody it was too late to speak, ma'am.
It was after you vote. I
Oh,
got
yeah, it was
chance.
after we voted.
Yes.
But you did speak during the presentation.
No, she didn't.
Oh, you had a representative.
Yes.
Yeah, well, he speaks for you, or she speaks for you.
Yes.
But if you have new information, we'd be happy to take it, but it sounds like he just wants to appeal this, so. Well, Donald, we're ready to vote.
On the request for reconsideration, Commissioner Fan.
I don't see anything new here. I'm going to vote to deny.
Commissioner Ford.
Excuse me just 1 second here. I don't really see anything here that is different from what we looked at before. My vote before was based on the numbers of the stores that I looked at that weren't really doing that great. So I'm going to vote to deny as well.
And Chairman Bradley.
I'm going to vote to, I don't see any new information. I'm voting to deny. Thank you.
Thank you.
Next is 1537, 3018 HP Ave LLC.
Good afternoon, Commissioners. The last time I was here, we were waiting on the community board meeting.
I'm sorry.
Yes, sorry.
What number?
It's 1537.
Go ahead. Sorry to interrupt.
No problem. We were waiting on.
You're the applicant.
I'm representing the
You're the
applicant.
representing, okay.
Okay.
Where's the applicant?
They're not here.
Okay.
Why?
Because the last time I was here, you just told us to take care of the community board with that issue, and the meeting is tonight.
Okay. So you want to adjourn?
Yeah.
Okay.
I had sent in for an adjourn, but Mr. Roper
Sure,
had sent back.
10:26?
Yeah. 10:26 is good.
Thank you.
Yeah, thank you.
Good luck.
Okay.
Next, 1497 Classique Bar and Lounge, Inc.
Good afternoon, Martin Miller of Malone Buscemi. This is a request for reconsideration of a determination of the New York State Liquor Authority where they rejected the offer of $2,000 and countered with it with a cancellation. I respectfully submit that, with all due respect, it's a little too much to ask this licensee to give up its license. He's had it for 18 years. I realize that he violated the provisions that he signed up for, in a sense, when he made the application, but I am now taking steps to get that rectified with a change in method of operation. He's going before the community board on the 28th. I'm sorry. 20, the 20th. And he has been in touch with the community board. He has every reason to think that they will be favorable. I've given you a letter of support from a local politician indicating that this place has been a benefit to the area for the last 18 years. And if you'll notice,
Here's the problem, and he now wants to get a DJ legally, and he's already shown, besides having a DJ, that he can't abide by the law, which, all right, we'll say he was ignorant or whatever the case may be. But now he's also shown that he can't operate properly with the DJ because he's got disorderly premises, which means that he was playing way too loud, and it ended up in complaints. You know that we don't end up there unless there's complaints.
I understand that, but
So
this was an anomaly.
Why would we give him the DJ?
This was an anomaly, Your Honor, Mr. Chairman. The 18 years of having this place is not a violent place. It doesn't incur disorders. It doesn't do.
Well, he's got a history of disorderly premises, like general violations.
But they
During COVID, or right before COVID.
Going back to when he first got the license, he's got a history of disciplinary.
Well, and that's my point, I guess, is all right, say we don't close him and we just fine him. He's not getting a DJ.
Under any conditions?
Well, maybe in a year of no problems, but he's already shown that he can't operate the DJ effectively. Or maybe he operates it too effectively.
Mr. Chairman, if the community board, after listening to...
Come on, it's a Bronx community board. They are not, they rubber stamp stuff like it's going out of style.
Well, sir...
But I'll take the cancellation off. I'll accept 15,000. I'm not accepting 10.
So, on the request for reconsideration.
Well, they didn't. Oh, go ahead.
Well,
I agree with Chairman. I'll vote yes on reconsideration and counter it 15,000.
Commissioner Ford?
I'll do both as well, but I will allow you like a recorded background music, but not a DJ for you.
Well, he's not asking for the DJ today, but he's already put that application in according to Mr. Mallon.
Yes. All right, I understand. Let me.
And I'll do the 15,000. I'm just saying, make the application for the DJ come before us. If the community board can justify why they think someone with his history should have a DJ, then they can certainly try.
All right. Well, that's all.
But I can't think of a reason.
Well, that will be another argument another day, and we've had a long day as it is now. So let's go on. All right.
It feels like it's long.
Stay on down. I got this one.
All right.
Next is 1509 Island Seas Lounge, LLC.
Again, Martin Mailer, Malone Buscemi. The address is not relevant. This is a request, a CNC actually, and it was my understanding, based on conversations with counsel's office, that it would only concern itself with the code violations that were found by the...
First, the CNC, just so the record's clear, was for 10,000, and that we withdraw focal point, sustained pattern of noise and disorder, and the noise and nuisance charge, which are charges 1, 2, and 4.
Correct.
The withdrawal's not happening.
Well, may I,
That's one. And I don't care what the police say to you or say to our investigators or say, the bottom line is they're charged. If we're going to get into a factual argument, we go to hearing. We go to hearing and he loses, whatever I offer and they offer goes up to cancel and bond after hearing. So, but we don't dismiss charges because for whatever reason, somebody decides they can't be proven. If they can't be proven, then we'll go and roll the dice and see what we can do. Because I think when a cop gets on the stand and we put their hand up and make them swear to the Bible, I would hope that the police officers in this city would tell the truth.
Well, as do I, but I mean, again, I don't really want to go into the merits. You're right, this is not a disciplinary proceeding at the moment. But with all due respect, they had meetings with the CO. They showed to the CO's satisfaction that it wasn't there.
So let me tell you, and I don't know the CO, I haven't spoken to him, but I probably will. The reason that this happened was because there were people in the police department that weren't satisfied with what the precinct was doing. And they went and did it on their own, such as the Vice Squad. And that's why there was inspections being done, including people from our agency, because for whatever reason, and I'm not going to speculate on what the reason is, the police in that precinct weren't doing what other police officers thought should be done. And I commend the officers that did do what they did because they obviously found issues. The guy's been open just over a year when all this happened. We already have one dead body and multiple people that have been injured. And from what I'm told, he's in an isolated area. So there's an argument that there's some bar that's not licensed that's the cause of it. Well, these people are dying. The person died in front of his bar. I don't care what other bar may be causing it. And if you think that that's factually relevant, that should go to hearing too.
No, I am not going to argue with you.
So
in
where
terms
we're
of-
at is, where I'm at is the charges remain. It's a CNC $20,000. We're not dropping anything.
So counter offer 20,000.
And after hearing, it goes, for me, they have to vote. After hearing, it goes to cancel and bond. And I don't care if they're all sustained or not. Because I'm not, the fact of the matter is people are getting hurt. And if they're not going to do their job, I'm doing mine.
Commissioner Fan.
I was already at cancel and bond, so I'll go to 20,000, yes.
And Commissioner Ford.
I'll go to 20,000 as well.
That's counter,
I thought
right?
10,000 was kind of low considering the history anyway, so.
No, there shouldn't be any history. It's a year old.
I know.
All right, thank you.
Thank you.
Next is 1519 Pub Carnegie Inc.
Hi, good afternoon. My name is Jae-hee Hong. I'm here appearing on behalf of Pub Carnegie Inc. and on behalf of Daniel Baggett.
Where's the applicant?
Well, he had a very high fever for a couple of days and then he tested
All right,
positive.
come back again, 1026.
Okay. So it's mandatory for his family member.
Oh, yeah,
Aunt.
no, he's got to be here.
Okay.
So, yep,
2
return
weeks.
October 26th.
October 26th?
Yeah, that's the next meeting.
Okay.
Commissioner Ford, you okay with that?
Yes.
Okay.
Okay. Thank you.
Yep. Next is 1500 KX Hunter Deli Inc.
Good afternoon. My name is Sam Park representative. Here's the owner, Mr. Kim.
Morning or good afternoon by now.
Yeah, it is, isn't it?
You understand now what conditional approval means versus approval?
Yes.
Do you understand it?
Yes,
You sure?
he totally understand that now.
I would think, Mr. Park, you would understand. You've
Yes,
been here
I
a few
understand
times,
that.
right?
All right,
Go ahead, Donald. I think we're.
I'll vote to approve.
Commissioner Ford
Approved.
and Chairman Bradley.
Approved.
Thank you, boy.
Good luck.
Appreciate it.
Thank you. Sorry you have to wait all day
50
for
of my
that.
guys. I said I could have brought 50 of my customers.
Thank you.
Next
You
is
need to do that.
1506 MS Family Food Corp.
Good afternoon, Commissioners. Gregory Capone, Kidanakis and Corona PLLC. This is a corporate change application. We had received a deficiency. We responded to it. There was an additional question posed. I have the bulleted list of questions, and I'm happy to address them one by one, or however you'd like to go.
Describe the structure of the supermarket cooperative.
Absolutely. The America's Food Basket Cooperative is composed or comprised entirely of independently owned and operated supermarkets.
So let me stop you there. So it's a cooperative, there's no ownership interest between the supermarkets, there's no...
None whatsoever.
They're just a cooperative.
The only functions of the cooperative are, number one, to engage in central billing. So obviously, the more Oreos one orders, the cheaper per unit they'll be, and a shared IP.
So this cooperative is loaning, has loaned the corporation money?
And that's actually, believe it or not, typical and customary within the...
So wait, that's yes or no, yes?
Yes, it is.
Where are they getting the money if these entities are not related?
Certainly not from the other entities, I believe. And again, I'm not a representative of the co-op. So
how does this cooperative acquire money? Is it collecting dues from the other members? Where are they getting the money to loan to the licensee?
that is beyond my knowledge, but I do know that it's typical and customary.
It's not typical in liquor license. So you're basically saying an entity that has no real legal existence.
There is a corp. It's America's Food Basket, Inc.
No, that's a corp. So where are they making their money?
The way that I understand it is, I mean, again, that corporation has officers, directors, employees. They engage in lending to their
So it's like an
clients.
association that they're employees of.
With
Is it
it-
not for profit?
Without, it is not a not-for-profit, and again, none of the supermarkets individually are owned by or managed by, in any way, shape, or form, the quote-unquote cooperative itself. Everybody's a member, everybody pays dues and pays into it, and in exchange, they get billing preferences, they get the ability to use certain IP, AKA.
So I don't know why they would be loaning money to a.
Well, here's the thing, they're not, and this is what I understand. America's Food Basket is not loaning money to Espinal and Lopez to buy out the stock from the two Santanas. They're loaning it to the corporation. So why is the corporation getting the money
to buy out stockholders?
And the answer is, as the member and as an entity with obviously assets, right, an entire supermarket worth of inventory and equipment, the corporation had the collateral necessary for the bank for the lender to be induced to loan.
If I want to buy a car.
Are you a lawyer?
I'm an attorney, that's correct.
Go ahead.
I mean, if I want to buy something, okay, and let's say I had a business, all right, I want to buy a car, okay, the bank doesn't loan my business the money so I can buy a car, it loans me the money so I can buy the car.
If the bank is willing to take your word and doesn't need a collateral that you might not have.
It's not, they're not buying the stock, the corporation's buying it.
And then giving it to them. For no, it appears, money.
Well, the ultimate result of all this will be these two individuals owning 100% of the assets of the corporation.
Yeah, but the corporation is just giving it to them. None of the money that none of the purchase price is being supplied by them. The corporation that they're buying is taking a loan for their benefit, buying stock from two other people for their benefit. So they're going to own a company and not have paid a dime for it. The corporation's going to pay for it.
And the stock was transferred a couple of years ago.
Right, before they filed their
Right,
application.
and part of this agreement is another corporation being on the loan because of their collateral.
I can, Devon Food Corp, the quote-unquote affiliate,
When you say affiliate, affiliate to me is a legal term. It means that they are owned by similar principles. They're affiliated.
And
So is that what's going on
the
here?
principals of Devon Food Corp are Denise Espinal's husband and father.
So they're not affiliated.
I would consider that affiliate, at least in terms of, they're
Well,
certainly
now-
related entities in terms of the
Well, so
ownership.
why are they're getting money out of this? I think some of this money is going to,
Marketing, advertising, and they purchase together.
and then even the numbers about how the money is being distributed is different, depending
Well,
on
I
what
can-
document you look at.
I'm gonna suggest, we can't approve this the way it is. So
So
I'm not
what-
gonna waste any time, and I'm not gonna sit here and try to work out what you're trying to do.
So-
But the corporation, when someone's going to buy a company, the company they're going to buy doesn't supply them with the funds to buy it.
In this case, it appears that
That it
that
did.
may have indeed happened, and I
Yeah, well,
cannot.
we can't approve that because that's not a corporate change. That looks like a theft. But one, two, this other corporation that appears to be financially involved, just because family members own companies doesn't make the companies affiliated. There's no common ownership here. So that, on a liquor license, is an issue because then we have what's called a valent.
Under the bankruptcy code, I think the entities would be affiliated, and that's again,
how you
I
just- you
was
just
I was a
mentioned they're-
bankruptcy
they're
practitioner
owned-
until recently.
You just mentioned that they're owned by four completely separate individuals.
By individuals with blood and
Yeah, but when we talk
marriage
about affiliated,
relationships.
okay, if people
My
are-
brother owns a corporation. I own a corporation. They're not affiliated. Just because we might be in the same business.
For these purposes, all I'm asking for is how do we proceed from here?
I'm not, we're not in a position, I don't know what the financial.
Well, if there's a restructuring of this transaction, even if it needs to be unwound in some way, shape, or form.
But you have,
So all I'm asking,
you have this list of the bullet points,
of
right?
course,
I would use that as the blueprint to go back and fix this.
okay. It is, the problem, of course, is it's going to be a little difficult to go back in time and sign. I mean, we can annul all of these agreements and redo them. The problem is one of these quote unquote steps, right? Because there were two transactions. One of those has already been approved as a corporate
The
change.
stocks were transferred long ago.
For no money, it appears.
And that's mistake number one.
I would disagree that they were transferred for no money. There was most
Well, no,
certainly
no, no, no.
consideration.
It doesn't matter if they were transferred no money or not. They were transferred before you got the approval of the authority.
The contracts, in fact, both say that the closing is conditioned upon the approval by the SLA.
So then just cancel it and start a new one.
I was going to say, if you'd like, the problem is I can't undo the first one at this point, right? The SLA has already approved the current shareholders as all four of them.
The current arrangement, okay, is,
Denise 25, Nicholas 24, and 25 is in percent and also number of shares.
there are 4 people right now on this license.
Correct. And the point of this transaction is to remove David and Antonio.
Right, we
And, right.
got that, yes. But everything else has to be addressed.
And I would go to a corporate attorney who specializes in these kinds of restructurings or refinancing, because you can't have the corporation buying its own stock back and then handing it to somebody else. It can buy its own stock back, but then it just means there's less stock out there. That's denied.
I will do what I can.
Thank you.
Fan, Commissioner Ford.
Yes.
I vote to deny.
Just taking note.
I can imagine.
Next is 1545 and 1546, Pyramid Exotic Bar and Resting. Did no one
What
sign
number?
in for that?
45 and 46.
Doesn't look like.
They don't have to be here for this. We can just do this. Somebody here for Pyramid Exotic Bar and Restaurant?
I might have
Frank?
messed that wrong.
Sounds like one of your clients.
If you want to go ahead.
Yeah, well,
It's in the Bronx. He won't represent people. from the
Alex.
Bronx.
John Springer is who apparently signed in.
4,500.
I'll accept.
All right. 1520 Lucky Spot Deli and Grocery Inc.
Good afternoon, members of the board. My name is Faris Hamtini. I'm from the law offices of Faris Hamtini here for the Lucky Spot. I have my client, Simon Asfour. It's the second time he's before this panel.
Yeah, did he tell you what happened on the first one?
Yes, Your Honor,
Do you
actually.
remember? Were you representing him then?
It was correct, yes, Your Honor. And I want to first take an issue with the question as posed in the agenda for this board.
Don't do that.
Okay.
If
I may.
In my estimation, been punished enough. I'm going to vote to approve.
Commissioner
I'll vote to
Fan,
approve.
Commissioner Ford.
I vote to approve as well.
Good luck.
That makes me the greatest attorney ever. You have to talk. Thank you.
Thank you.
Next is 1527 W&J Liquor Inc.
You can't do anything like this.
Good afternoon, everyone.
It's here.
My name is
because-
Hong Chen.
Hold on just for a
Oh,
second.
sure.
I'm just explaining why this is before the members, okay?
Oh, okay.
In the advisory that you issued about changes to package stores, okay? This is essentially in effect them trying to make the package store bigger by by using a warehouse, and it'd be like, it would.
So what's the distance we use?
We don't
Two
use it, we're
blocks.
using size. So they're
So if
going.
they were 5 miles away but bought a 30,000 square foot warehouse, it would still be here?
Unless the members want to give us more guidance as far as.
Okay, I do. Go ahead.
My
So
name
this
is.
just to get this going, this is a warehouse you're getting, a warehouse permit, 3 blocks from her current liquor store. How big is the warehouse?
The warehouse is 2,300 square feet with a office space.
All right, you're approved.
Oh,
Commissioner
approved?
Fan.
Yes.
Oh, okay.
And Commissioner Ford.
Oh, thank you.
So just for the record.
Okay.
I will bring the.
Let's
It's okay. Don't worry.
2 blocks away.
You're
Yeah,
fine,
yeah,
go.
it's all
We're
good.
done.
It's not here.
Just for the record, so I would say anything over a mile away, regardless of size, there's not much we can do about it. How do you argue that?
I will have to bring the advisory back to the members to clarify that.
Doesn't Empire have one in New York City?
Yeah, but that was all done way before that you put this advisory in.
No, leave it, don't do it, because we don't get that many.
Next is
Next
1504
board meeting.
Dose Dudes LLC.
It's all the work you guys.
What's that?
1504 Dose Dudes.
It's just all the work you.
Those
I have
dudes.
nothing else to do with 11 o'clock at night.
Here comes the two dudes right now.
That's quite appropriate because the whole day I'm like, who are those dudes?
They're the two dudes.
I think for the record, it's 3 dudes.
It's 2 dudes. My name is Frank Palillo. Would you dudes introduce yourselves, please?
My name is James Hurst. I'm Hayden Tobin.
Say the names again.
Hayden Tobin.
And
And James Hurst.
you guys related? No. Same hairdresser?
You guys should be in a band.
Is this
I'm
being
not making
recorded?
funny, I would kill for that.
Is this being recorded? It's an application
One of
for.
you is a musician, right? One of you is a musician.
I had been a professional world touring musician for many years, but no longer.
All right, I see you have STIPs with the community board. Your hours are 2 to 2. Did you straighten out with the CB that it's not a restaurant, it's a tavern?
It was corrected afterwards,
Okay.
yes.
All right. Go ahead, Commissioner Freeman.
Bert, I'm going to vote to approve with the following conditions. I'm going to allow the bathroom waiver, no security guard, manager to be hired, and you're going to submit his personal questionnaire, his or her, and 2 private events a month, no third-party promoters, recorded background music only.
Commissioner Ford
I'll agree to the same terms.
and Chairman Rath.
I'll agree to the same terms as well. Good luck.
Thank you.
Gentlemen.
Yep, thanks for coming in.
Next is 1529 Lenny's West Indian Cookhouse LLC.
1529.
1529.
Good afternoon, Matthew Leone for the licensee. I had planned to have my client here as well, but he had a personal matter to attend to today. I'm hoping we could resolve this. It's a conditional no contest plea.
Fine, 2,500.
2,500.
My only question, Mr. Loney, was, he didn't really explain why the cognac was there in the first place. He says he's trained everybody, but he doesn't say, like, why was it there in the first place?
Well, what I can tell you is that he knows it should not have been there. And he doesn't want to lose the license, and he's told me, and I hope to represent to you that it's not going to be there. It's gone. It's not going to be sold there anymore.
We're going to take your word for it, and I'll accept it as well.
And Chairman Bradley.
Accept.
No, you accepted?
Okay. Thank you.
Yep. 1505 Springs General Wine Shop, LLC.
Frank Palula.
Daniel Bennett.
Uno, dos, two.
Uno.
Why is this set up like this with you managing and then there is an LLC? Like, how is this? Is the LLC that's applying and you're the manager of the LLC?
Well,
Yeah,
as per Commissioner Donahue.
So we've had issues where there's a holding company that's the principal, but then there's no person. And we issued an advisory about this. So the applicant amended the application to make it clear that the applicant LLC has 3 live bodies who are, right? Then there's the holding company, and they're also the LLC members of the holding company. But they're the live bodies, so to speak, who are signing documents who will sign documents if this is approved for the licensee.
I won't comment.
Okay.
Why, do you have one?
No, I do, but I can't.
Well, then next time there's a renewal, there's no one to sign the renewal application.
The sole managing member of a holding company. I won't comment.
So the other issue here is the zoning. Not that I'm gonna get into that, but did he fix that?
I didn't think you
yet?
wanted to go into it.
Did he fix that?
East Hampton had a problem with the zoning.
No, it's not. Got it.
Well, they claim they do, but you resolved it?
Yes.
No, they did resolve it. Okay.
Yes.
Yeah.
Go up. Microphone.
How secure is the shed out back?
Yes. I'm sorry?
How secure is the shed?
The
Pictures of it look to be like,
The shed where we'll be storing the alcohol in the back.
Oh, yes, that's very, very secure.
And that's not going to be part of the license permit. You get a warehouse permit for that,
Correct.
right? Yes.
You own Lulu on 8th Avenue?
I'm sorry?
Is one of your restaurants Lulu on 8th Avenue?
Lulu LLC on,
That's a different one.
Is it different?
a
now?
different, yeah, I don't have a.
Babo, right, or
Babo.
what's the name of your restaurant?
Babs?
Babs. Right.
Babs
Yeah,
on.
I've been to it.
Oh. Was it all right?
Uh-oh. Uh-oh.
No, I don't, believe me, when I go out, I don't look. Except the hotel today that I stayed in.
I see. But there's no history on any of the restaurants, right?
No.
Lulu must be some kind of French. Is that a French saying or something?
Yeah, my partner is French. We also have another one, Jack and Alice LLC, that's been open for 8 years. Also,
Oh, I'm familiar with that one too. Because
They're
there
both
isn't,
in the
there is
city.
an LL,
They're
a
both in
Lulu
this-
on 8th.
Yeah, that's what I'm
Avenue.
asking,
Yeah.
because they got burned down
Yeah.
with
Oh,
the
I see, I
outdoors.
see.
That's
So
what
it
I'm
must be a
asking
French
him.
saying, because I think
Yeah.
there's one in France, in Paris too.
C'est la vie.
But
C'est la vie.
So we are getting multiple letters from the town saying they haven't decided.
They're saying they resolved it, though.
Do I have something saying that?
Does the town have a say?
not in my view, no. They can shut you down if you're not zoned right, but I'm not
Correct.
gonna do it. That's their issue with him, not me. Same thing with the C of O. They want to enforce, I don't know if he has one or he doesn't, but if he didn't, that's their problem.
And the other stores did not protest.
No, I think one did, but I think it's closed since then.
Springs wine is closed, you're saying? I mean, it says here that it's currently expired.
Yes, it closed. You live right down the street from it. Yes.
I double checked, it's still expired.
So this is like 150 square feet. What's the business model here?
Yeah, it's the Springs General Store has been there for a very long time. We purchased the property. We're going to run the Springs General Store as it was, just a little general store, but we wanted to have natural wine in this little tiny auxiliary shed that used to be kayaks. I saw the P&L for that. It obviously never generated any income. So we thought, because there's not a solely natural wine store out there yet, and a lot of those stores are kind of edging into that, that we might do something that was small.
You've got pending application for on-premises license for the general store right there. That's the beer license, right? Or the
Wine and beer. Wine and beer. Yeah.
Oh, that's going to be a luncheonette or something too?
Yeah.
Okay.
Yes.
All right, I'm ready.
Just for clarification, it's not a package store, it's a wine store.
Right.
Commissioner Fan?
Yeah, I'm gonna vote to approve.
Commissioner Ford?
I vote to approve as well.
Chairman Bradley?
I'll vote to approve.
Thank you.
Thank you very much.
Good luck.
Next is 1502, 523 Restaurant Court.
Good afternoon, Commissioners. My name is Ben Korngut. I'm the attorney for 523 Restaurant Corp. I have with me today Andreas Papadopoulos, who is the sole principal of the licensee. This is an application for a change to the...
So Donald, I think we're ready to vote.
Yeah,
on this.
since the community board sent a letter saying no comment, I'm going to vote to approve with extending hours to 4 a.m.
Commissioner Ford?
Approved.
I'll vote to approve as well.
Thank you.
Thank you. You deserve that for waiting so long. Thank you.
All right, Jonathan and Nikki, there's nothing else, correct? No. We're good? All right. This says 1498. It's an offer of letter of warning.
Accept.
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 So 1503, we received an email from the rep. They're withdrawing the application.
Okay.
And I confirmed with the rep that there a misunderstanding about what the current hours are.
Okay. Fine.
Can someone remind him he's not supposed to be using promoters?
They're going out of business.
1507, got an email from the attorney. The applicant is out of the country, asked for October 26th or November 9th.
October 26th.
So before we go further, Tom, why wouldn't this be something you would just deny at LB?
I was...
And that other one too, by the way.
I was tempted to deny both of them, but
All right.
I wanted to give a chance to explain.
All right. I mean, it's your work. I'm trying to decrease it, but go ahead.
You know, actually, it's more work because now I have to write a disapproval. So
Oh,
now Donald has to write it.
Well, not for a little bit.
So what, he's out of the country? What's he asking for?
So the applicant's out of the country. He wants October 26th or November 9th.
26.
Commissioner Ford?
Yep.
1511 is an offer of 2000.
And the license has been renewed.
This is a sale to minor. Fine. I'll take 2,000.
To provide a fake ID that look legit, right? Is that the idea here? I'll accept.
1513 is an offer of 6,500.
6,500.
Accept.
6,500.
1514 is an offer of 2,500.
2,500.
2,500.
Accept.
1515 is an offer of 2,500.
2,500.
2,500.
Accept.
1516 is an offer of 2,000.
2,000.
2,000.
2,000 accepted. Just licensed though, too.
1517 is an offer of 6,000.
6,000.
6,000.
6,000 accept.
1518 is an offer of 2,500.
2,500.
2,500.
Accept.
That's the one I mentioned to you too about.
So 1528 is basically the brand label registration.
Can you explain the issue here for all of us?
On which?
I was
1528.
Brand label?
Yeah.
But
Alright,
what is the alcohol content of this?
I don't think we know.
It's 160 proof, it says here, but
Well, 160 proof is 80%, yeah. So someone submits an application for a brand label. We also look at the packaging and the container, because the statute allows us to look at that as well. We saw this and we were concerned that the packaging in little spray bottles might be deceptive to the public.
What? Because it's in a spray bottle?
Yeah, I mean, if you look at them, I would never think this was an alcoholic beverage.
But you could think it's hand sanitizer. Which
Well,
is also
if
poisonous.
if you've used the state's hand sanitizer,
Well, I mean, that'll kill you, whereas the alcohol.
So it's my understanding, this is meant not it's meant to spray on it in another cocktail as a
Yeah.
garnish.
That's what I was gonna ask you. What do you spray this on?
Oh, you don't just
A
spray it
salad?
into the mouth?
No, well,
You spray it into
well,
a
here's the
salad?
thing though.
Let me ask you, what do you spray it
There's
on?
nothing to stop you,
But this
okay?
can only be sold at a liquor store.
I,
It has to be 80 proof.
yes,
I mean, 80%
well, no, I
alcohol.
believe this is a liquor product, yes. But it also could be sold at.
So we're not talking about the product here, we're talking about the packaging.
Right, and whether or not the product as packaged, okay, is deceptive to, and we weren't gonna, the brand label unit wasn't gonna make a call on that itself.
Yeah, I don't think it is, but you
Well,
guys.
it's only gonna be sold in liquor stores, right?
Yeah.
Correct.
So I guess we can.
Well, liquor
assume-
stores and on-premises establishments could sell it to people,
Well, they could only sell but they can't sell the bottle. Not on premise, they can only sell the product.
They can sell the spray bottle.
And on premise? It's supposed to be a mixer, it sounds like. You're
It's
certain
not,
they could sell like a can of beer.
and yeah, unless it's restricted how, unless you're saying, we're not restricting it to say, okay, the bartender can use it and spray it on a cocktail, which is then served. Arguably, I'm not saying they would, but arguably, they could just have a, display of these and sell these to people in the bar.
Right, and then they would just spray it on.
Or spray it into their mouths or
I don't
whatever.
know that that's a.
I think it's fine.
Okay.
It's probably
All right.
better than taking a whole shot.
All right, Donald, I think we're ready.
I don't garnish my bourbons, I don't
Commissioner
know.
Fan.
I'm okay with it.
All right, Commissioner Ford.
Yep.
Vote to approve the
And
I'm
brand.
going to
Chairman.
vote to approve the brand label, not the appropriateness of the product itself.
1530 is an offer of 12,500.
12.5.
Accept.
Accept.
1531 is an offer of cancel and bond.
Cancel and bond.
Accept.
Accept.
1532 is an offer of 10,000.
10,000.
10,000.
10,000.
1533 is an offer of 2,000.
I was gonna go to 4,000.
4,000.
For 1533?
Yes.
Okay.
They have since gotten approval for the security guards.
Oh,
Yeah. I was an accept.
I'll take 2,000 then.
Wait.
2,000.
Okay.
Approval.
1534 is an offer of 7,000.
7,000.
7,000.
Mr. Ford.
Which one was that?
1534.
Well, this is awesome.
This is definitely bound.
And a sales minor.
I was at
Next one.
10,000.
10,000.
1534? Yeah.
Where yes, Commissioner Ford.
I was at 10,000.
Wait, 1535?
1534.
Okay, I'll go to 10,000.
10,000.
1535 is an offer of 2,000.
Should be canceling bond.
I agree.
This is human trafficking they got arrested for and convicted.
Yeah, it's indentured servitude. Cancel and bond.
Cancel and bond.
1536 is an offer of 5,000.
5,000.
Accept.
5,000.
1538 is a request for a declaratory ruling. Ended bar.
No, this was the mixing machine?
Yes.
Yeah.
So this is no. I do not think that the proposal to collect and store and transmit biometric identifiers and information from New York State residents, it's appropriate here.
Do you decline to issue or do you?
So I decline to
Or do you want a declaratory ruling?
I decline to support it.
Yeah, she's saying no.
I'm not
The
declining to-
declaratory ruling is it's not legal. I would add to what she said, in that the machine also won't take any cash. And it's only credit card use or debit card only, and I think in the past, we have voted against things that were credit card only, correct? Stores.
I think that New York City may have
They made a statute.
Yeah.
a local law about that.
Yes.
You can't just take.
That they
credit
called
cards
it discriminatory, yes.
But what else I don't remember reading in this was, I remember reading the mechanics of how the machine worked, but I don't remember reading who supplies the alcohol, who refills it, where it comes from. So I had a lot of questions like that, so I vote to deny as well.
1539, it's a no contest default at pleading.
3,000.
3,000.
3,000.
1540 is an offer of 1,000.
I'll take 1,000.
1,000.
1,000 accept.
1542 and 1543 is an offer of 2,000.
I accept.
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 1544 is an offer of 3,500.
3,500.
3,500.
Accept. Should one of these charges be dismissed, counsel?
Yes,
So
it's
which one?
duplicative. Should be improper conduct on tax cigarettes, and just go with the suspension of cigarettes.
So accept and dismiss one.
Dismiss one. It's fine.
Okay.
Chairman says yes.
Dismiss or withdraw, doesn't matter.
Withdrew.
Yeah,
Withdraw.
withdraw is the. 1547 is an offer of 1,000.
I'll accept 1,000, but they need to file change of method of operation if it's true that they are
Supposedly, according to
No
Ms.
longer
Mosquito,
serving.
closing at 11 p.m.
Yeah, they need to request a change of hours, etc.
I had this one possibly going back to council. I don't know. If it was they paid all the penalties for other offenses since. I don't know. You just want to accept, Commissioner Van?
Yeah.
Accept.
1548 is an offer of 1,500.
I'll accept.
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 1549 and 1550 is an offer of 5,000.
I'm gonna counter at 10,000.
That's what I counted at. Counter at 10.
Counter at 10.
All right. So I have nothing else, Chairman. Do you have anything?
Nope.
All right. This meeting's adjourned.